petition allowed.
Number 47.
Appeal dismissed.
Number 48.
Petition allowed.
Like, hello, origin record is there, maybe. Please don't know, origin record.
Yes, any mention?
May I please your lordship? I beg to mention item number 54 with the consent of the other side. On the last occasion, the case was fixed for 28/8, but inadvertently
Yes.
on the last occasion, that is 24th of July, the case was listed on 28th of August, but on the hearing day, but inadvertently today the case has listed. Therefore, I beg to mention item number 54 for listing on 28/8 of 25.
So when do you want?
On 28/8, my lord. 28th of August.
The prayer being made by Mr.
Eke Hanman, my lord.
Learned Counsel appearing on behalf of
MJ Kadir.
Mr. MJ Kadir, Learned Counsel for the appellant, dismissal is the matter on 28/8.
Yes, my lord. My lord. With the consent, with the consent.
Okay, with
May I please your lordship?
Yes.
I am praying for listing one RSA matter for orders, my lord, and I am any date except 38th of this month.
Get it?
First August.
May I please, Lordship? Lordship, I beg to mention item number 53, Lordship. Item number 53, Lordship, I filed an IL, Lordship, for withdrawal of the petition, Lordship, CRP, Lordship. After matter listed in orders column, Lordship, instead of Lordship withdrawals column.
I number 53.
Lordship, item number 53.
50.
53,
You want to withdraw this CRP?
CRP, Lordship. I filed one IL, Lordship.
Is listed today.
Lordship. But it is listed on a orders column, Lordship. Can it be, Lordship, on withdrawal column, Lordship?
Oh, I will call it.
Lordship.
May it please your lordship, I beg to mention item number 6, lordship. Lordship, this matter may kindly pass over for the day, lordship.
Step number 6.
Lordship.
The prayer being made by Ms.
Ardeka.
Arteta, Learned Counsel for the appellant. You inform the other side.
I take the consent of the other side.
Consent for the other side. Press for adjourning the matter for the day. There is accordingly allowed. The matter is adjourned for the day.
Obliged.
May it please your lordship, I beg to mention 2 IS for listing under order column.
When?
Next month, any date.
On 6th August.
One second.
Yes.
Lordship, I am praying for listing of an CRP IO, Lordship.
When?
Any date in next week, Lordship?
No, which one?
Orders column.
May I please, your lordship?
13th August.
I
13
beg to
August.
mention item number 24, lordship. In this case, lordship, earlier occasion we were directed to take steps through paper publication upon the sole respondent, lordship. But lordship, appellant is very poor, lordship. He is unable to. The money is required for paper publication. 2 weeks time may be given, lordship.
2 weeks.
2 weeks time may be given.
Okay. On the prayer being made by Mr.
JM Gogol, lordship.
J.M. Gogoi, Learned Counsel for the petitioner. SSR is the matter after 2 weeks.
2 weeks, lordship. Obliged.
May it please your lordship. Lordship, I beg to mention for listing of an IA for condonation of delay, lordship. Any date, lordship? Any date next?
I beg to mention for listing of RSA, lordship. RSA number 63 of 25, lordship.
For hearing or
Lordship, appellant want to withdraw the appeal, lordship, unconditionally,
more.
lordship.
May I please, your lordship? I would like to mention for listing of a MSc appeal, lord.
When?
On 30, if possible, lordship. Orders, it was ordered. Much of it. May I please, lordship? And lordship, I beg to mention on CRP case for listing
Chairman,
CRP case
when?
on 30.
Yeah,
Lordship, I beg for listing of one RSA and one RFA under orders column. Any date, Lordship.
7, 8.
May I please, your lordship, lordship, I'm here for this court to list the matter of the MAC appeal 7231 2022, your lordship,
When?
for early hearing,
When?
for next month,
Hearing.
for all this.
26. Board withdrawal. Number 49.
Yes, Mr. Law Court.
Lordship, the matter amicably settled, my lord. So I was instructed to withdraw the.
Mr. Law Court learned counsel for the appellant submits that the matter has already been set to withdraw the same. We are taking note of the submission of Sir Law Court learned for the appellant. Its appeal disposed of on withdrawal. Withdrawal.
My
This is a different answer to the learned court will.
obliged.
Item for motion, item 1.
May it please, your lordship. Lordship, this revision petition is against one transfer order, lordship. By this transfer order, 2 suits were transferred to 1 court, lordship. Their application is at page 38, annexure 4, lordship.
Have you filed objection in that petition?
No, lordship, no written objection, but oral objection was there. And lordship, the order is illegal as because 2 suits from 2 different courts were transferred to 1 court, lordship. Having 2 pecuniary jurisdiction, one is lordship civil judge senior division and one is civil judge junior division, lordship. Both the suits were transferred to civil judge senior.
It relates to the same plot of land.
No, lordship, but
Even
the
the same-
pecuniary jurisdictions are different, lordship. The appellate authority are different, lordship. Civil judge senior division case will be appealable before the district lordship high court. Their pecuniary jurisdictions are different, lordship. And while one application, lordship, 2 suits are sought to be transferred. Your lordship, kindly see their application page 38 annexure 4. Relevant portion, your lordship will find in page 42, lordship. Paragraph 3, that the aforesaid suit is pending before the Honorable Court of Civil Judge Senior Division for service report and written statement. So 1 suit is pending at the stage of written statement, lordship. In the said title suit 56/2023, the present plaintiffs were arraigned as pro forma defendant in title suit number 36 of 2022. 36 of 2022 was filed by the petitioner, lordship, and that reaches the stage of judgment, lordship, before the Court of Civil Judge Junior Division number 1. So they have admitted that both the suits are pending before 2 courts, lordship, having 2 jurisdiction pecuniary, lordship. Now the title suit 36/22 is fixed for argument. The suit lane mentioned in title suit number 56/2023.
No, maybe,
Covered.
but there is no direction to try both the suit together. The
But lordship,
judge has directed to proceed differently.
but lordship, the jurisdiction will be different for deciding both the suit. One was lordship called from junior division and one was called from senior division, lordship. That is illegal, lordship. Pecuniary jurisdiction is not, lordship, having both the senior division does not have pecuniary jurisdiction to decide that title suit, lordship, 36/2022. And their case, Lordship, paragraph 5, your Lordship, kindly see page 43, that the land contained in title suit 56 2023 are same in title suit number 36 2022. So both the suit are urgently necessary to determine by the same court jointly by separate independent judgment on the same day. So their Lordship intention is to, Lordship, stay my suit, which reaches at the stage of judgment, Lordship. And
a pair was not allowed.
yes, Lordship. But Lordship, taking the benefit of transfer, now they will again may pray for Lordship that joint trial may be allowed. And in fact, Lordship, the entire order is illegal. Both the courts are having two different jurisdictions. Civil Judge Senior Division does not have jurisdiction to decide the suit of Civil Judge Junior Division, Lordship. Valuation are different, Lordship, in both the suits. I have annexed both the planes, Lordship.
So do you have any decided case on this point?
Lordship, it is settled that as because Civil Judge Senior Division will decide above 5 lakhs and Senior Judge Junior Division will decide up to 5 lakhs, Lordship. And valuation of the suit are, Lordship, already mentioned here in the plane. And in fact, the first suit was, that is 36 2022 is filed.
Is there any bar that the civil judge senior division cannot decide a case
Lordship.
where the pecuniary jurisdiction of the case is tribal by the civil judge junior division?
Then, Lordship,
Is
one
there any
they will lose one appellate authority, Lordship. Then I will satisfy your Lordship with the judgment of authority.
Let's fix it on another day.
Yes, Lordship.
Sorted.
Lordship.
Hardness or learned counsel for the petitioner.
Lordship.
Obliged.
My pleasure. But I have a very bad case. Bad case in a sense that I am the defendant in this suit. And I prayed for filing evidence on affidavit in so many occasions. And the learned trial court closed my filing the evidence on the affidavit. And the case was fixed for argument. My simple prayer before your Lordship is this: a last chance may be given by imposing a cost.
So, Mr. Sharma, you see, you have already availed as many as 5 days, 5 adjournments.
No, I admit, everything. Your Lordship has the jurisdiction under 227.
No,
A
that's
license,
restriction is there, but
a license may be given by imposing cost. And the other side will not be prejudiced.
heard Mr. S. from a learned senior counsel assisted by Mr. Learned counsel, petitioner. In this petition under Article 257 of the Constitution of India, the petitioner has challenged the order. 17th of June 2025 prospects learned civil just new division Vakeshwar in title for 2 of June 11. This will be noted declared by review or dated so the learned the senior division has dismissed. This is the petition number 215 of 2020 filed by the petitioner for allowing holding another day for submission of evidence on affidavit of defendant. And that's it. Learned senior counsel for the petitioner submits that admittedly, the petitioner has availed several dates for filing evidence on affidavit. Filing evidence on affidavit. But this submits that this court has a jurisdiction to allow the petitioner unable to constitution of the evidence on affidavit. Some topics. Having heard the submission of the client counsel for the petitioner, I have carefully gone to the petition and the record. Then also prioritize in order to get 17/6/2025. It appears that the learned court has dismissed petition number 1215/2025. Filed the petitioner for granting another date for filing evidence in the petition. That is then side.
Yes, sir.
It also appears from the petition number 1215, which is annexed with the present petition as annexure number 4. That due to ill health of defendant number 1, who is undergoing treatment at Guwahati, could not file the evidence on affidavit. Whether you have enclosed any medical document in sub petition?
That was actually not reflected in the petition, madam. But statement was there. Actually says in Guwahati for treatment. That I know.
Taking note of the submission of Mr. Sharma, learned counsel for the petition. So, given actual scenario, this court is inclined to allow this petition. Allow this petition. The impugn order dated 17/25 is sent to the second person. Consequently, the court below is directed to accept the evidence on affidavit and side subject forward payment of deposit of rupees 10,000, which shall be deposited to the learned trial court on the date 10,000.
Yes. Maybe first week of September anything.
No, yeah, we have this place.
Hello.
Number 3.
Lordship, we are aggrieved by the order at page 100, Lordship.
Let notice for here.
Lordship. As to do, Lordship.
Learned. Yeah. It is not a.
25/4/25.
Civil just report. Execution case number 18 of 2015. It is to be noted here that by the further dated so the learned since the petition number dismissed. What are the numbers of petition?
Lordship, page 119, petition number 497.
Pardon?
Page 119, Lordship, petition number 4979. 119, page number.
petition number 152 of 2019 and 4979 of 2024. Where is the license record and also where is the impugned order dated 4/25? Issue notice to the respondent returnable in 4 weeks to be taken by registered post with AD and also by usual process within a week of it. List of 4 weeks.
Item number 15 for referring to the special mediation right.
May it please your lordship. Other than the matter was listed, and I informed that I had a word with Mr. Paul. In fact, he's busy he's stuck up in some jam, I believe. I had a word with him in that he requested for taking the matter for some time, although he has no objection to the matter being sent, only his name being recorded. The difficulty which comes in this bill is because, my lord, if lordship takes up page 6, where the impugned award is there, page 6. But this was a head-on collision. Everyone died in the wagon. Charge sheet was submitted with the authorities against the truck, the offending vehicle. But the eyewitness was there who said he saw the accident. Everyone, that his friend also was in the car, died. The insurance authorities laid witness and they said that no, the car dashed the truck from behind. And the learned tribunal, without any materials on record, accepted that. And that's how the award was passed. Well, page 6, the name Bina Devi, who's the claimant here in Madam, wife of late Om Prakash Shah, who died in the accident. The lordship takes up page 8.
No, sir.
My lord, I'm only praying for remand to consider, because page 8, the claimant's husband is shown as different, number 1. But he is stuck up in a jam, he said. But he has no objection to the matter being. Yes, but I'm not against him. The award is against him. What we are saying, it should be against the insurer of the truck. I'm not even against him. This is, I'm not taking an order against him. Rather, it's in his favor what I'm submitting. Up to your lordship. My lord, 2020 hearing matter. But we only want a remand to the authorities. My lord, lordship.
So we have heard we have
What should be hearing the at 2, my lord. At 2.
For admission, item number 4.
May I pray, your lordship? Lordship, what has happened in this case is there was a plot of land which was earlier in the name of the petitioner's father. The petitioner's father expired. The land was mutated into the name of his mother and the petitioner. Now, lordship, the private respondent had filed a complaint. That was referred to the court of the sub-judge. Now, the learned sub-judge has passed the impugned order, which is under challenge here. But in the meantime, lordship, actually there is an appellate authority, which is the court of the judge. That time, at that relevant point of time when the petition was filed, that post was vacant. The lordship may relegate the matter back to the competent authority, that is the judge.
That is?
That will be, lordship, the court of the judge. I'm sorry, lordship. No, what did I say? It will be the judge and his autonomous council. Lordship, since I'm already protected by an interim order by this honorable court, lordship may continue with the interim order.
Yes, Mr. Das.
Lordship may kindly peruse the order dated 7/4/25. It has been reflected clearly in that order, Lordship.
7/25.
Passed by Honorable, yes, passed by Honorable Justice M.K. Kolita.
Order dated
7/4/25. Clearly, it has been reflected there, Lordship. There is a provision of appeal before the Court of Judge, Lordship. And the judge has also already been appointed in the year 23. So matter may be remanded back to the court to decide, to the council.
The method.
It's a land dispute, Lordship. It's a land dispute that tribal people land dispute matter. So there is a provision, Lordship.
Who deal with them at
The court of the judge,
Court of
North
Judge.
Kachar Hills. North Kachar Autonomous Hills Council. No, it will be Dimahasa Autonomous Council Court.
It has been reflected by the petitioner itself in paragraph 3, page 7, Lordship. Rule 30 provides that an
the numbers?
Paragraph number 7.
page 7,
Page
paragraph
7,
3.
paragraph 3.
It's in the middle line.
The petition.
Yes,
Yes,
in the
Lordship.
petition.
Rule 30 provides that an appeal shall lie to the district council court from the decision of the subordinate.
Party of voice rule.
District Council rules.
Court. The rule has been quoted in the paragraph 3 itself, Lordship.
Okay.
It starts from page 5, Lordship.
And the court.
Lordship. The court is managed by. No, this is the judge, Lordship. Council judge, Lordship. Lordship. Since there is a provision in the district council court itself. So if matter may be remanded back to the court for decision there also for a decision.
The matter is not taken up by the regular court.
At that time, Lordship, when the order was passed, the Secretary Revenue and the judge who was sitting in that fort is the same person. Was the same person, not is, was the same person at that moment of time. But in the year 2023, a judge has been appointed, Lordship. Her appointment order I have already given there and kept as a record. But this one is her appointment order, Lordship. Council judge has been appointed. So now, since there is a full-fledged judge is there, so Lordship may remand the matter to the district council court to decide the matter afresh.
Oh, wow. The matter is taken up by the regular because already bill just taking all courts are there.
Yes, Lordship. As per the provision of the
North Kachar Hills.
North Kachar Hills court
Justice
rules,
1955.
there is a provision. So as per that provision only, it's in.
So actually what is followed is Lordship, the North Kachar Hills Autonomous District Administration of Justice Rules 1955. That governs the issues in the North Kachar, in the 6 schedule areas, in the North Kachar Hills.
That's all right, but in Nagaland also there are Lugasi courts, but there is a decision of imprisonment of this court, so they right with the regular courts.
And Lordship will give us some time, let us go
No,
to the judgment.
it is there, Lordship, it is there. But since it's an appealable order, means order passed by the subordinate judiciary of the North Kachar Hills Autonomous Council Court. So there is a provision, as per rule only we are stating, that rule 30, which has been quoted by the petitioner also in page 7. Rule 30 provides that an appeal shall lie to the district council court from the decision of the subordinate district council court in any case, civil or criminal. After that, they can approach the civil court, Lordship. If they are being aggrieved by this order of this court, then they can approach the civil court. which is in Haflong.
Where it provide
Lordship,
is provided in the rule.
In the rules of 1955,
yes, Lordship.
Provision.
Rule 30.
Rule 30.
अपना आने से नहीं बेटा कौन
Be with you.
Right now, I don't have, I can show it to your Lordship. If Lordship may grant me 1 hour time. Or at 2, if the Lordship may fix the matter, I can show it to your Lordship. I have that book, Lordship.
Okay, we are-
Can it be some other day?
Today only, Lordship, because from the last 2-3 occasions, the petitioners are taking time, enjoying the interim order. So, Lordship, I am requesting your Lordship, since it's pending matter, Lordship.
We are
think better, disposal of the there is.
Yes, Lordship, I will satisfy your Lordship by providing. Yes, yes.
But other issues are also to be looked.
Yes, definitely, Lordship. I will provide the book, Lordship. I will satisfy your Lordship. At 2, Lordship.
I have some difficulty doing Lordship. Let it be tomorrow.
Tomorrow is hearing the day after tomorrow.
Day after tomorrow, Lordship. I think 28, 29, 30.
That's acted in learned that this is comparison day after tomorrow.
Lordship. 30th second. Obliged, Lordship.
You have produced the relevant rule
Yes, I will, Lordship.
of this court division that year 2000.
I will.
I'm appealing for respondent 1, my lord.
Okay.
My lord, item 5 and 7 are same, my lord. In fact, there are 10 appeals, my lord, only 2 are listed. But we will admit this first appeal, my lord. And Lordship can, I have a prayer for under order of 5, my lord, the Lordship will stay the operation.
You have filed interlocutory application.
My lord,
You have filed IA.
yes, IA in both the cases.
My lord was staying the thing, the private party may appear after that.
No, let a notice go, my lord. The letter-
Because he has to be heard, man.
No, my lord, let a notice go and your lordship will, till then, my lord, till the other side appears. your
Status
lordship-
quo may be maintained.
No, since there is a time frame given, no, sir, what is the purpose of it? Stay is definitely, it's an appeal is admitted. If an appeal is admitted, lordship will stay the matter. And let the other side come, then my lord, lordship will decide. Till the other side appears. Or even status quo also, but not,
So what I say is for respondent number 2.
my lord.
I am for respondent number 2, yes.
Oh, you are it.
I am, no, I am for the state of Assam.
Number 1 is private party.
Yes,
That
yes.
side, only not.
Actually, the land was acquired, my lord. And against that order, the reference code, they have appealed. So that is why, my lord, it is their land. It was acquired through us. I am appealing for the DC.
He is
for the
with
state
me.
of Assam.
He is with me, my lord. He has secured
Yes.
for me, my lord.
Okay. Heard Mr. Roy learned new counsel assisted by Mr. Learned counsel for the appellant. And also heard Mr. Bhattacharya for respondent number 2. In this appeal under section 54 of the Land Acquisition Act 1894. Judgment and decree dated 21/2/2025 passed by the Lord received the Scarborough Birmingham in reference to December 30 of 2014. Peruse the memo of appeal and the grounds mentioned therein. Then also peruse the impugned judgment. And decree 21/2/2025. Admit, issue notice to the respondent, returnable and for which step be taken by registered post with AD and also by the process upon respondent number 1. However, no further notice required to be issued to the respondent number 2. Since Mr. Bhattacharya appearance and notice, however, expert requisite copy of the petition will furnish to him during the course of the basis to follow the record of the learned court below. Place the matter after all weeks. I heard Mr. Roy learned senior counsel, assisted by Ms. So learned counsel for the applicant, and Mr. Bhattacharya for the respondent number 2. This application under order 41 rule 5(1) of the CPC is prepared by the applicant for staying execution of the decree dated 21 to 2025 passed in reference is for 30 of 2014. Passed in the learned district just coming down. Mr. Roy, learned counsel for the applicant submits that the applicant has already prepared one appeal. The LA appeal number is also, and the same has already been admitted by this court, and notice has been issued and elected. And as such, there is a requirement for staying the impugned judgment and decree dated so till disposal of the appeal. Till disposal of the, let notice be issued to the respondents, opposite party, returnable in 4 weeks, to be taken up with respondent number 2, no, respondent number 1. Number 1 by registered post with AD and also by legal counsel. And considering the submission of learned counsel for both the parties, it is provided that status quo be maintained as on today till returnable then.
No. Deeply blessed. Item 7 may not same order. Only the numbers will be.
And the amounts are also different.
The amount
Amount paid are also different.
numbers.
Item 8.
May I please, Your Lordship? Your Lordship, this is a miscellaneous first appeal, an appeal under section 23 of the Railway Claims Tribunals Act, Your Lordship. I have challenged, Your Lordship, the judgment and order dated 17/3/2025 passed by the Learned Railway Claims Tribunal, Your Lordship, while dismissing the claim application filed by the appellants, Your Lordship. Your Lordship, this is an untoward incident that had happened with respect to the late father of the appellants, Your Lordship, who had died while boarding the train, Your Lordship, and the train was supposed to be traveling from Bokachan railway station, Your Lordship.
Third is a TS Teka, learned.
Yes, sir.
For the appellant. The appeal under section 23 of the 5 of Railway Claims Tribunal Act 1987 is directed against the judgment and order dated 17/3/2025 passed by the Learned Railway Claims Tribunal bar defense in OK certificate Brahma to Q stroke ZHY stroke 650 stroke 2024. Is they noted here that by Q judgment and order dated so and so the Learned Tribunal has directed. What is the operative part of the judgment?
Yes, Your Lordship, I'll just take your, yes, Your Lordship. The operative part of the judgment and order, Your Lordship, is at page number 43, Your Lordship, 42, conclusion. On the above findings on issues framed in this case, it is evident that the claim application is liable to be dismissed, and I hold so. Your Lordship, there has been framing of 3 issues.
Learned Tribunal has dismissed that petition preferred by the appellant. The of appeal and the counts mentioned therein admit is not be returnable in quick step is taken lesser so it can be also by legal process. This is the call for the record of the Learned Tribunal. Place the matter of for
Much obliged, Your Lordship.
Please, Your Lordship.
yes.
This is on against the judgment passed by the Land Commissioner, WC Commission, Employees Compensation in Barpeta, Lordship. Yes, substantial questions, Sir, Lordship, in page number 6 of the appeal memo.
Third is. Policy against the judge for employees compensation for fees and seats of the order detention as directed. Hearing to pay compensation on this number of fees.
3,10,130.
In lakhs, then
130.
132 lakhs.
130.
It's a memo of appellant account mention of it and also ordered it, but before it was substantive question of law, yeah.
Lordship, A, B, C.
Which of the question according to you is
A will be learning. A, Lordship.
A.
A may be, there are three, but A will serve the.
This appeal is attitude of the following substantial question of. So while listening the conclusion, the commission count the opinion of the doctor.
No,
Loss of.
Lordship, the doctor, Lordship, in fact, I have filed Lordship several cases on a similar sort of illness, Lordship, that is affecting the ear, Lordship. And doctors are, same doctors are practicing for Lordship. I'm just telling off the record. They are neither radiologists nor orthopedics, but they signed on some laboratory reports. Well, and that's not their own also. This comes on, not their own. And there shows there's no malunion of bones, no some kind of deformity of the bones or malunion. And yet they always come to a standard percentage, 37, 38%. It's not based on sound medical practice. Apart from that, there's a Lordship refrain in 4.1c. It says that it shall have due regard while making assessment. The doctors shall have due regard to the percentages specified in Schedule 1. That is in relation to amputation. If the amputation of one finger is 10%, how can a fracture of the be 10%? That's kind of, it's supposed to be, suppose in accordance with section 4.1c. That is my yellow section. These assessments are not in accordance with section 4.1c of the Act.
Tribunal has, Commissioner has not assessed the compensation as per section 4.1.
1c. That is my discussion.
whether the pending arrived by the commissioner in respect of the loss of earning capacity at 38% suffers from person who non-consideration of the provision of Section 4(1)(c) of the Employees Compensation Act. Which provides assessing the while assessing also earning capacity, the report of the qualified medical practitioner shall have to be given due regard to the percentage of loss of earning capacity in relation to different injuries specified in the CPP. Issue notice to the respondent.
Yes, sir.
That be taken by registered court, AD and also by the council. Rest shall call for the learned evidence. Lays the learned commissioner, workman compensation or better. This is the matter after 4 weeks.
It's a year per stay lost.
Please, your lordship. My lord,
Yes, lordship.
Have you ever of the heart? Have you decided?
Lordship, before my learned friend starts, lordship.
my lord, I am the appellant, my friend is
No,
arguing first. Yes.
No, I am not arguing. I'm just pointing out to the court that in this case, lordship, they have a interim payer. It is in the memorandum of appeal. And normally, lordship, for interim payer, one interlocutory application is required. If they would file an interlocutory application, then I will file my objection in that IA, lordship. For that only, I am pointing out whether your lordship is taking up today itself or on some other day, so that they can rectify their memorandum of appeal. And in fact, the decree was also not annexed with the memorandum of appeal, lordship. For that only. Now my learned friend can start, lordship.
My lord, my prayer is that at this stage, the appeal may be admitted, my lord.
Okay. Yes, but yeah, whether the rule provides for an IA.
Yes, lordship. Order 41, Rule 5, lordship.
My lord, interim, I am not urging for at this stage interim, my lord. Only my prayer is the appeal may be admitted.
Only admission, I have no objection, lordship. As because
I am not
lordship,
file any interrogation, how I can pay for interim, my lord.
there is
So,
an
my lord,
interim.
only for
There is an
appeal may be admitted, my lord. This is an appeal, first appeal, not a second appeal, my lord.
In appeal, admission, I have no objection, lordship. It's a regular statutory appeal, lordship.
Yes, there. Learned at home.
Interim petition দিব লাগিব petition দিব লাগিব immediately
First by learned civil
record call কৰিলে automatic আহি যাব
So be noted by interim judgment and decree ordered to control the body. Civil the senior division provide our has partly taken for school. Where is the performance of the council there again? Also, where is the Mr. You have not enclosed the decree yet.
my lord will my lord furnish it my lord will furnish by an additional revenue difficulty बात है जान
At least notice so this regarding for it. How this is required to be issued. Madam, you are representing all the respondents.
Yes, lordship. 1A, 1C, and 1B, lordship.
How notice is required to be issued since solely for a council entered appearance and receipt notice on behalf of all the respondents. However, extra requisite copy of the memo of appeal be furnished to her during the course of the hearing. This is a call for the record of the court. Place the matter after 4 weeks. By Sotari Pera learned counsel for the respondent pointed out that the appellant hearing have and so passed by the learned court below. So signal learned counsel for the appellant submits that he will bring on record the said degree by filing an additional affidavit. They are allowed to this number of purposes.
Obliged.
Lead lovely.
May I please your lordship? Lordship, here I am a caveator for respondent number 1. So I would like to file my objection, lordship.
Before that filing the objection, I want to place some of the situation for which this application has been filed for granting for temporary injunction lordships. Because this appeal has
Temporary
been
injunction,
prepared,
lordship, in the-
appeal has been prepared against the dismissal of the injunction application filed by the appellant by the London Trial Court below, based upon the grounds of that the appellant has not produced the status quo order passed by the honorable court in another first appeal honor. Second, the ground has been taken by the learned court below, your lordship, that the suit has been in the possession of the defendant number 1. And thirdly, your lordships, the honorable learned court below has a taken of the view that the if the suit property, the construction of houses which has been carried out.
Okay, let him file objection.
Lordship, here what has happened? I am obliged, lordship.
Heard Mr.
H. Burra, lordship.
Borua, learned counsel for the appellant, and also heard Sir Vertices. A Vertices, learned counsel for the respondent number
1, lordship.
1 and
For the
2.
caveator. No, for 2 I have not filed wakalat number till now.
Lordship, sir.
Let a notice be
But
issued.
the caveat has been filed for defendant number 1 and 2, your lordships.
Kotha koi re? Be clear with the records. Only for respondent number 1, not for 2.
No, caveat has been filed for the defendant number 1 and 2, specifically stated, your lordships.
Fourth. Where stated? No, lordship, it's for only for the defendant number 1.
and the procedure for respondent number 1.
1, lordship.
Yes.
As a caveator.
Order 43 R. Order 43 of the Code of Civil Procedure is directly against the order dated 8/5/2025 hospital law. Legislators senior defendant number 1 and 1. Peruse the memo of appeal and the grounds mentioned therein. And also peruse the impugn order dated 8/5/2025. That it issue notice to the respondent. However, no formal notice is required. That's why furnished me brings
সেটা ফাইল করছিল লোয়ার কোর্টে উঠতে গিয়ে পুরো পার্টি ছিল স্কুলের
what says the learning copy for the respondent number 1 and said he may be granted some time to file objection in the IA.
In the IA, lordship.
The IA. Bear allowed place the matter after
2 weeks.
2 weeks.
Your lordship, I pray for interim protection if your lordships.
No, it is at the vague end of the argument stage, lordship.
No, your
They are
lordships,
coming now.
There is a construction has been going on.
Where construction
Changing
has
the-
been going on? There is no construction going on, lordship.
I've produced these photographs. If the change of within 2 weeks, your lordship, if the change of nature and character of the suit line has been there, there is a better enter maybe.
What will happen if construction is going on?
There's a construction. We admitted the construction is going
No,
on.
I am not admitting the construction is going on. I am putting a question to my friend that what will happen,
No, Lordship.
whether he will
change
lose
the
his right,
entire change of
whether
letter
he will
to
lose his
letter-
right, Lordship. He will get a part thereof if this his suit is allowed.
No,
If
Lordship.
he has filed a suit for partition, Lordship, partition in his shares. Suppose I construct a 3-storied building and partition is allowed, he will get a share of the 3-storied building at my cost.
No, Lordship.
How he is prejudiced?
Entire
He
thing
should
has
be
to
happy.
Entire thing has to be in a difficult position for me.
He should be happy. He should be very happy that he is getting a 3-storied building at my cost, Lordship.
No, Lordship, my question is that nature and change, nature and character of the suit may be difficult. It is difficult for me to recover back, your Lordship.
How can?
Third
He has
party right
filed a
should be
suit for
created.
partition.
Third party right will be
That has
created,
to be
Lordship.
understood what he has filed. He has filed a suit for partition.
Please, yes.
Lordship, if the construction has been going on, in my apprehension, the properties may be sold out to any third person or letting out to the third person. If the third person be come out to my place, your Lordship, that the third party right will be created. That is my big
So,
Lordships.
Is pending before the learned court below.
Lordships.
So whether there is any chance for petition of any third party?
Lordship, because the learned court below has, while dismissing my injunction application, the category stated that if the suit property has been letting out to the third party, the defendant number 1 could not be restrained. That is my biggest apprehension. You see, if the property, the way the construction has been carried out, if he has been let out to the third party right to be created, your Lordships. The multiplicity of the proceedings be going on, your Lordships. That is my biggest apprehension, your Lordships. Nothing else.
Third parties are not available before this court today.
No. The
Number 20.
respondent number 2, because respondent number 2, he has been sold out a part of land to the respondent number 2.
No.
No, agreement
is why I'm
agreement has been
saying.
made. Agreement has been
Yes.
made. Because pendencing of that, because what is there is a lot of thing has been come out before the honorable court
My
below
brother,
also.
don't mislead the court. Agreement
the-
has been made in the lifetime of the.
The agreement has been made during after the main question is the sale deed has been put into question before the learned court below because of lack of undue influences, and there are some of the grounds that has been put into challenge. But because of this, because of the suit has been pending, your Lordships, and injunction has been not been granted for raising construction any kind of building. The defendant number 1 has categorically divided divided the entire suit line into different parts, your Lordship. The entire nation character of the suit line has been changed. That is the biggest apprehension before this honorable court, your Lordships. If this injunction has not been granted, my entire should be redundant, your Lordships. Till filing of the objection, I may be the opposite party number at least restrained, not to construct. Thereafter, after hearing, your Lordship, we vacated the entire my injunction.
First of all, Lordship, no construction is going on. No construction is going on. Some buildings have collapsed, some renovations has been done, and the wall has been there for protection of the land. There is no injunction. The suit is a.
Have you seen the
Yes, I have seen, Lordship. They have placed it in the lower court also.
new construction?
No new construction is going on. Only a protection wall is there.
Annexure 4.
Lordships.
Annexure 4 of the FAO or the IA? Lordship, these were already there.
No.
Before the suit was there. These are only renovation part going on. And some boundary wall is there.
Annexure 4 and
I've seen Lordship Annexure 4.
it's not new construction.
No, not at all.
That's why these fixes have been laying on a plot of land, and why the
And Lordship, this honorable court earlier on a FAO being filed by them, this honorable court has simply put an embargo at the alienation of the land. Nothing to do. And the suit, Lordship, is pending in the stage of argument.
That order is still operating.
yes, still a party.
We have not
Status
alienated.
order has been granted for.
No status quo order has been granted.
I've annexed the order.
Why you are
I have
arguing
annexed
without
the-
any records? You have newly entered the suit at the
No.
back end. Let me argue now. You have completed your argument. Let me argue. Don't pick on the middle of the point.
28.
Lordship, there was an.
Let him come.
Okay, then let him complete, Lordship. Let him argue for hours he want.
No. Lordship, there is a status quo order. I have annexed this status quo order in Annexure D of my IA, Your Lordships.
Page number?
Page number 50, Your Lordships. Lordship, Annexure E, Annexure E, page number 52.
No, no,
Order dated 28/2/2020. Considering the same, the status quo in respect of the title of the suit property shall be maintained till the next date fixed.
Thereafter, it was extended.
Yeah, the case has not been placed before this honorable court, Your Lordships. Thereafter, the status quo order still prevail in this case.
Another status quo order is necessary.
Because they are constructed a new house in the suit land.
If there is a direction to make how they can construct.
That is why we have approached before the landed trial court below to not to construct the any houses over the suit property, but they refuse. The landed court below overlooked the entire matter and dismissed our IA Lordship for temporary injunction also applications. This order has been still prevailing in this case, but negating the status quo of this orders passed by this honorable High Court, they have raised the construction Lordship.
No, if the order is still in force, then where is the petition of first second order?
No, because the application has been filed for not to alienate the property or not to alienate, the prayer is not to alienate the property, not for any construction or renovation of the property or to letting out not rent to any party. That prayer has not been made before the landed trial court below. But this order has been dismissed landed trial court below. We filed an FIO and status quo order has been passed. But the thing is that since the no construction order has been non-restraining the construction has not been preferred landed trial court below, the defendant number 1 has raising the construction over the suit land. That is why we have preferred. Yeah.
Order. What do you mean by status quo?
Status quo order, Your Lordship. Because in this that application, we have prepared for not to alienate the suit land, not for we have not made a prayer for construction. We have not
specified in this order.
Lordship,
is it specified in this order that this not to alienate the land third party?
Yes, because the paragraph number 2, Your Lordship, that this application under order 13 and 1 and 2 of CPC filed by the petitioner against the opposite party seeking an interim injunction restraining the opposite party and from selling, disposing any part of the suit property in favor of the opposite party number 2 or third party stranger till disposal of the connected appeal. That is the pair.
Yes, Mr. Patisha.
Lordship may kindly come to page number 55 now.
50?
55 of the IA filed by them.
Yes.
Status quo in respect of the title of the suit property shall be maintained till the next date fixed. That is the title. There is a question actually here. I purchased the entire suit land, and during the lifetime of my father, when I purchased this entire suit land, they never came for any objection. After my father has expired, after a period of 3 years, from the date of expiry till 3 years, they remain quiet. After 3 years, they have filed a partition suit. Now let us understand, Lordship, what they have filed. They have filed a partition suit. Now in a partition suit, suppose they succeed. So I will have to give a share of the land to them. But Lordship, till now, the suit is in the stage of an argument. They have given only one evidence and that has been closed. In the stage of argument, they have come up with several petitions piled up before the lower court only for the purpose of delaying tactics, Lordship. They know very well that it has been, after the sale has been executed, Lordship, record of rights, my name has been entered, they have never objected. Never they have objected that how we have purchased it. And this sale deed, Lordship will kindly see, has been executed before the office of the senior sub-registrar. Now they are using a term where I have got a strong objection that it's a fraudulent sale deed.
have they ever tried to bring up evidence that it's a fraudulent sale deed? Have they called the sub-registrar to prove that it's a fraudulent sale deed? No. Evidence has been closed. Suit is in the vague end of argument. They're not arguing. They're shying out from the argument. We have argued the case. After we have argued the case,
How many, the case has been listed for argument?
No, Lordship,
5 times, Lordship.
not,
Five times,
next
3
date is,
times.
next
Just
date
a
is
moment.
338.
No, Lordship, I don't encourage this.
Lordship.
Lordship will kindly see. 5 dates this was fixed for argument. 3 days I have argued. 3 days their previous lawyer has argued. After that, they file a petition calling from certain documents. And we have filed an FAO before Lordship. Your Lordship might be aware because it has been listed before Lordship. And we have categorically stated that now they are trying to reopen the suit. Now, Lordship will kindly see and kindly appreciate that at the stage of argument, without arguing on their case, without arguing the material on evidence, they are trying to reopen the suit, which is not permissible at all. And now at the vegan, they want injunction. The court below has said the court is going to finish off the suit within maybe another 3-4 dates. They want injunction now.
Okay, after 2 weeks.
Let me file my objection, Lordship. Develop that.
Here, all the parties,
Yes, my lord, APR, my lord. Your lesson number 1 to 5, my lord.
We are
Yes, APR.
representing, Lordship.
So Kayum, there was a direction of this court to obtain instruction when the this only
Yes, my lord. My committee, my lord, the present committee was constituted on my lord 5/3/2010.
5-3.
5/3/2010.
So it was a written instruction or a verbal?
My lord, I have the copy, my lord, but it is in Hindi, my lord. I cannot read the Hindi, my lord.
Do one thing, you bring the same on record by filing an additional.
Yeah, then,
Heard, so the Kayum learned counsel for the. Means heard so the learned counsel for the. the Kayum learned sooner applies this court that person to order this court 2025 be applied instruction regarding the constitution of Sri Sri Sip Dam conflict. And he has also received written instruction that same was constituted in the year 2010.
10, 5/3/2010.
And accordingly, it is provided by Excel bring on record said instruction, written instruction by filing an additional affidavit. Less than matter on public. 8 August. For admission hearing.
But sir, after 15 million, I have some problem.
Before that, if lordship, the my suit has been stayed, lordship. So after 15, can it be on 16, lordship? 16 Sunday, Saturday, 18, lordship, then Monday, lordship. Obliged, lordship.
Interim miller shall continue. There is an interim miller.
Sir,
Obliged.
There's a direction to serve a copy to the council for the other side, but inadvertently on the last occasion, it has not been served. Today I have served the copy. Can it be taken up day after tomorrow, lordship? On Wednesday, lordship. On Thursday, lordship, if it is possible. First order some difficulty.
Agreed by learned advocate for both of them.
Then lordship on fourth, lordship, I will be out of station on first. Fourth of August. Obliged.
Item 14.
May please, your lordship. I'm appealing for the appellant claimant and is against the ex-parte judgment, ex-parte dismissal judgment dated 21/5/2025. And I'm the widow of the deceased, and there's a motor vehicle case, and the opposite party here happened to be the Union of India. But the judgment, and that has been passed, there has been, my lordship may kindly see the ground number 3, where there is a manifest error. There's a manifest and fundamental error in not framing the issues. Issues hasn't been framed, and the learned tribunal failed to frame the material issues arising from the pleading. And without framing the issues, the judgment has been passed. Ex-parte judgment has been passed for dismissal. So if you go to the entire judgment, we'll find that most of the part of the discussions are very vague, conflicted, and not clear. So my humble submission before your lordship that this case may be remanded back to the lower court after this one, because only thing that has to be passed, that has to be, that issue has to be framed. So there's no any other grounds. And even if you go to the operative portion, that is also another ground where they have said, where the judgment has stated that there is no rationalism on the part. But before going to the facts, substantial question of law here is not framing of issues. So not framing of issues is sufficient, which cannot decide it even in an expert case. So my humble submission before lordship that it needs to be remanded back to the trial court for framing issues. He was given a ground for the learned motorcycle claim trial number 3, Kamrup, error in law and facts in dismissing the claim petition ex-parte by order dated 20/5/25 without framing issues, they were depriving the appellant claimant of a fair opportunity to establish the involvement. Non-framing of issues goes to root of matter and has resulted in miscarriage of justice.
Admittedly, the appeal order is ex-parte order.
Ex-parte order.
So is there any necessity of having issues in
Even ex-parte order, there's a plethora of judgment, where even in ex-parte order judgment, framing of issues is required. Because otherwise things become very conflicted. If I go through this judgment, we'll find that things are not specific, non-conflicted, are very contradictory in most of the discussions here. So for getting a specific conclusion on issues are mandatory even in ex-parte cases.
No, you see, this is not a civil suit.
This is summary procedure, but the summary procedure also things has to be decided.
See, it's followed.
And even if we take a summary, but without the,
Let's do one thing today, let us submit the, let notice to the other side. After hearing both the parties, we will take a call. Regarding demanding the matter to the. Or research.
Argus for me.
Or something learned from. Against order detail. Plus by the learned man. Auto accident claim terminal number 3, Tamil and body in every case number 1063 of 2023. Is the way noted here that by the order dated so and so, the level has dismissed the claim petition filed by the applicant. There is the memo of appeal and the grounds of hearing. And also there is the impugned order 21/5/2025. Admit is notice to the respondent returnable. Okay. Gravical. Place the matter after 4 weeks.
May it please your lordship. Lordship, where minor the judgment was passed in a claim application, lordship, that was barred by limitation one. Its date of occurrence is after the new amendment has come into force, my lord, and the case was also filed belatedly, my lord.
Today we will admit the appeal.
My lord.
Or Mr. Polita learned only for the complaint is appeal under the competent particularly of an case is directed against the judgment and order dated 7/2/2020 plus the learned member for accident claim judgment. And as per in case number 26 of 2023. Is to be noted here that I think the government and word that the current is directed to the appellant hearing in sum of rupees. What is the amount?
Lordship, amount is small, my lord, 40,295.
40,295.
95.
As compensation to the but this appeal is maintainable.
Lordship, we are not challenging the quantum, my lord. If the quantum is under challenge, my lord, that in that case we cannot file the appeal. But we are challenging the finding, my lord, because the claim application was barred by limitation and section 3, the limitation act could have been applied and could have been dismissed at the threshold, my lord. We are raising the issue of liability.
The appellant submits that in this appeal, the appellant has not challenged the quantum of compensation. Rather, it Lord of criminal as the claim petition was for having been after 1/4/2022.
Yes, my lord.
1/4. The submission of the Bobita Garden Council for the this is admit the appeal. This one notice to the respondent returnable in 4 weeks have been taken by the circle with heavy and also legal purpose. This is a call for the record from the Lord and Tribunal. Is the letter of the 4 weeks. Later fair issue comes.
I for stage there, my lord.
That notice to it.
My lord. Much.
Pleasure, lordship. Also, in this case, the deceased was a government employee. His case is covered by the compassionate family pension scheme.
Was he was an employee of the
Archaeology department, Lordship. Director of Archaeology, Assam.
Department of Assam. What was the quantum?
Contra means Lordship 51 lakhs, 21,834.
Hard Mr. Arugosami learned counsel for the appellate. This appeal under section 173 of the NDA is directly against the judgment and award dated 4/4/2023, hospital learned member of resident and terminal of and working in MSc case number 1449 of 2018. File under section 156 of the NDA. That is to be fully heard at you order dated the learned tribunal has awarded the sum of rupees 54,834 rupees. Take the company to the respondent number.
So number one, Lordship.
Respondent number with interest at the date of rupees. At the date of
Interest at 9%, Lordship.
per annum. Per where is the memo of appeal and the grounds mentioned therein as also where is the judgment that taking. The judgment and award admit issue notice to the respondent following the application by registered post with AD and legal process.
There is an application process.
License to call for the record from the learned tribunal next of the
Deposit 20%. I'll deposit 20% Lordship. As per the judgment of the Supreme Court, he is entitled to only future prospect. That is about 15%. He was entitled to 15% of future prospect.
You want to deposit?
20% Lordship. Public Lordship.
Great decision, Lordship. Lordship, the grounds taken, Lordship, was that the insurance company proved the GD entry, Lordship, by which it was shown that the claimant himself was driving the vehicle, and in fact, he had hit another vehicle, and he made a false claim before the tribunal. Apart from that, Lordship, their statement in their own claim petition, FIR, as well as their evidence on FDB, it is totally contradictory, Lordship. And then, Lordship, the rest of the grounds are on quantum, Lordship.
Lordship, we have proved.
Respondent number.
This is only one Lordship. It capital. Claimant capital. We have proved our case by eyewitnesses Lordship, and charge sheet also filed against the vehicle Lordship.
This appeal under section. Yes, directed against when their order dated 3/3/2025 hospital learned member of resident body in embassy case number 454 of 2020. Is completely heard by the just and award letters so the learned person has directed appellant hearing pay example of this like
19 less.
54,000 who are there. Take the compensation of that of interest at the rate of 6% per annum. Date of filing of that. Is it?
Lordship, I'm just 6%.
This is amputation case Lordship. One leg is amputated above the knee Lordship.
In fact, page 36, it is not specifically written from the date of, it is just given 6%.
That the rate of 6% per annum. Where is the memo of appeal and the ground and comparing? Where is the judgments and whatever dated. For its indication registered for daily and also Let's call for record from the level of resident, please the records. I 50%?
Yes.
Lordship, we may kindly imputation case, Lordship. Only one
Lordship,
claimant,
let
we
us-
may kindly be allowed to withdraw, Lordship. Imputation case, Lordship. So the claimant may kindly be allowed to withdraw, Lordship.
You file a
Yes.
Lordship, since
Yes.
raise the will say.
Highly obliged.
my cabinet may kindly discharge, Lordship.
Yes.
Substantial question of law is at page 5. Last if we can, so far our contention as regards to our petition connected with the issue number 2, 3, and 5 are concerned. Lordship has sought the evidence to that effect, my lord. Reiterating, my lord, yes,
The direct to record the affidavit.
yes, yes.
But it's
That is not through my lord affidavit. I have not filed, my lord. I have not the document. My lord.
what was the direction of this?
Yes, yes, that's me. My lord, inadvertently, my lord, I was on such impression that my lord, it could be my lord submitted by hand. If you lordship found this, and so far, my lord,
You file it, we'll consider it. Yes, sir. Yes, sir. Sir, learn the concept. Submits that he may be granted something to file. To bring on record the evidence on affidavit filed by the regular for the learned record. By way of method. Here is allowed. This is the list of the of.
Friday or my lord, Monday, my lord.
Okay, next evidence.
All right.
Please, your lordship. Let's say judgment of reversal, my lord. The facts of the case, my lord, that my lord, the appellant before your lordship was the defendant before the trial court. Now plaintiff filed a suit for specific performance of contract. Trial court had dismissed the suit. Appellate court had reversed, being agreed, my lord, before your lordship. Now, for your moment, may I take your lordship to the, my lord, defendant, present appellants were the defendants. Initially, suit was dismissed. Suit for specific performance, which was filed by the respondent, that was dismissed. Against that, they preferred an appeal. The appeal was allowed. Therefore, we are before your lordship. My lord, may I draw your lordship's to attention to page 14, my lord. It is the suit. Page 14 is the suits. It's, and then lordship will kindly turn to page 18, my lord. Page 18, last line. Later, lordship got it, my lord. Later said Sachindra Burman.
Page number
18, my lord. Last line. Last line. Page 18, last line. Later said Sachindra. Later said Sachindra Burman sold a part of his 1 biga land measuring about 2 katha 10 lechas in favor of Arendra Burman and Girendra Burman, who accordingly obtained mutation in revenue records, right, SDC or dated so and so so and so. In this way, Arendra Burman and Girendra Burman individually acquired right title, interest and possession over their 2 kotha 10 lechas of land standing at 1 biga 5 lechas is, and they had been possessing the land by dividing the land verbally and amicably according to their convenience. So, my lord, this Horendra and Girindra, they have jointly purchased this 2 bigha 10 acres of land, and it was not partitioned amongst them. Their contention in the plaint is that they verbally agreed that yes, I will take this portion, one person, and you will take on. So there was no formal partition. Then my lord will the next para that after the death of Girindra Bormon, his son Dulal Bormon inherited a part of his land in Schedule B measuring 1 kata 5 lechas as legal heir, and accordingly the revenue record mutated in the name of Dulal Bormon. The revenue records for the share left by Girindra Bormon by order dated. So this Girindra's son, he had inherited the land after the death of Girindra. Then your lordship will come to next para, para 6. That due to financial hardship, the defendant number 1, Dulal Bormon, proposed to sell a plot of land measuring 12.5 lechas with dark number so-and-so out of the land in Schedule B at a consideration of so-and-so, and the plaintiff came forward and offered to purchase. After negotiation, the plaintiff and the defendant number 1 settled the consideration at rupees so-and-so for 12.5 lechas of land. Accordingly, on 7/11/2012, this is the my lord agreement for sale. On 7/11/2012, the defendant number 1 received a sum of 30,000 as advance payment and executed an agreement to sell the said 12.5 lechas of land out of Schedule B in favor of the plaintiff with certain boundaries. Now, my lord, in the previous paragraph, my lord, it is the plaintiff's pleaded case that it was jointly purchased by this Horendra and Girindra. There was no formal partition. Now, in absence of any formal partition, my lord, how the legal heir of Dulal, the Horendra Bormon, that is the Dulal, he could have entered into an agreement to sell a plot of land with specific boundaries. Because, my lord, that section 44 of the TPX says that yes, if you sell your share, subsequently partition will follow. Then by partition, you take your share. The share can be sold, my lord, that is not in dispute. But here the question is with certain boundaries. In an undivided, unpartitioned land, this Dulal Bormon, he entered into an agreement to sell this 12.5 lechas with certain boundaries. And the date was fixed, my lord, then para 7. I'll skip other parts, para 7. That at the time of execution, the deed dated so-and-so, the defendant number 1 received an amount of 30,000 as advance and promised to execute and register the sale deed in favor of the plaintiff after receiving the remaining amount within 2 years. So it was agreed that within 2 years, the payment has to be made, and within 2 years, after receiving the payment, the sale deed will be executed. Now, my lord, as regards the finding of the trial court, the lordship will kindly come to page 46, my lord. The judgment starts from page 46, my lord. The learned trial court had framed, my lord, issues, which your lordship will find at 7 issues, page 51. 52, my lord, these 7 issues were framed by the learned trial court. Now, this issue number 4 and 5, that was decided against the plaintiff, my lord. Now, issue 4, and therefore the suit was dismissed. Now, issue 4, my lord, it starts from page 55. Page 55, 56, and finding is at page 60, my lord. Page 60. 5th line, my lord, this in this first para, 5th line from bottom. Therefore, in absence of any concrete evidence. Page 60, my lord. 60. Therefore, in absence of any concrete evidence, it cannot be held with conviction that the defendant number 2 had received the consideration price on behalf of her husband, defendant number 1. Accordingly, the issue is decided in negative against the plaintiff. Now, the plaintiff's one of the contention is that after paying this 30,000, the plaintiff has paid the other portion, balance consideration on, to the defendant number 2, who was the wife of the plaintiff. So therefore, it's the court, learned trial court says that, therefore, in absence of any concrete evidence, it cannot be held with conviction that the defendant number 2 has received the consideration price on behalf of husband, defendant number 1. Accordingly, the issue is decided in negative against the plaintiff. And the next issue is issue number 5, whether the plaintiff is ready to perform his part of the contract and the defendant number 1 has avoided to perform his part on of the contract. Now, this issue, regarding this issue, the finding is at next page, page 61. Therefore, as the plaintiff, fifth line, my lord, from bottom of this paragraph, therefore, as the plaintiff has failed to prove that she has discharged her burden by paying the sale price to the defendants, hence it cannot be said that the plaintiff was or is ready and willing to perform her obligation. Hence, the issue is decided in negative against the plaintiff. Now, these two issues were decided against the plaintiff. Ultimately, my lord, the suit was dismissed. Against this, my lord, an appeal was referred. Now, the appellate court, my lord, while discussing these issues, issue number, my lord, 4 and 5, what it has held at page 14, page 95. Actually, what you meant, page 95? 95.
Yes.
Yes, para 14, my lord. Though the learned trial court has decided issue number 4 in negative, this court is in disagreement with the findings because the part of the evidence of DW1, namely so and so, so and so, and so and so, are not appreciated in the proper manner. DW so in a written statement admitted that he and his wife, DW2, are signatories in Exhibit 2. And he has also admitted his wife so and so has signed as witness in Exhibit 2. Exhibit 2 means that agreement for sale, my lord. He went on to admit that Exhibit so and so is the signatures of the wife, but he stated that he is not aware of Exhibit so and so are the signatures of his wife or not. Similarly, DW2 so and so stated that Exhibit so and so are her signatures. Such admission on the part of the DW1, DW2, first of all, shows the knowledge on the part of the DW2 in regard to the agreement for sale. That was never in dispute that whether there was an agreement for sale or not. On part of in regard to the agreement for sale, and therefore, this is important, and therefore it is immaterial if at all the defendant number 2 received any amount from the appellant because the contract was directly made between the plaintiff and the defendant number 1, and there is direct liability on the part of the defendant number 1 towards the plaintiff. Now, it is the finding of the first appellate court that yes, there was a direct contract between the plaintiff and the defendant number 1. So even if the plaintiff has paid to the defendant number 2, it doesn't absolve the plaintiff from discharging his liability. Now, in spite of arriving at this finding, the appeal was allowed. Then it says that, the learned trial court gave a finding that the plaintiff could not prove her claim with convincing evidence, and there was no such witness present during the time of transaction, as there was no authorization made by the defendant number 1 to the plaintiff to make payment to defendant number 2, but such appreciation was made without looking into the pleadings of the defendant number 1 and 2, and also the evidence rendered by the defendant number 1 as DW1. In paraswens of the evidence, it stated that whenever defendant 2 asks the plaintiff, as per the advice of DW1, to pay the remaining amount and to execute the register the sale deed, the plaintiff repeatedly requested to wait for few days for financial problems of the plaintiff. In the pleadings, there is no such specific denial that money was not received. Rather, no receipt of part payment was already admitted by the defendant. My lord, this is also, my lord, perverse, because at page 33 and 34, it is the WS. Page 33, there is a specific denial that page 33. If may I just pause here and draw your lordship's attention to page 33, my lord, which is the WS of the defendant number 1. Page 33. Clause C, my lord, from down below, my lord, second clause, clause C. Yes. After execution, so this is the evidence, WS of, my lord, DW1. After execution of the deed of agreement for sale, the plaintiff never paid money in favor of the defendant number 1, as well as failed to fulfill the contract as per the deed of agreement for sale dated 7/11/2012. So there is specific denial that no money was paid. Now, in spite of these pleadings, my lord, again I will take your lordship to page 96. How, my lord, the learned appellate court comes to a finding that there was no pleadings, my lord. In the pleadings, there is, I am reading, my lord, page 96. In the pleadings, there is no such specific denial that money was not received. Rather, receipt of part payment was already admitted by the defendant number 1. Further, the learned trial court did not took into account the demeanor of DW2 during her cross-examination as it was written by the learned trial court, recording the evidence that on question of the court as to why she signed in exhibit so and so exhibit 2, she did not reply. Later, she said that she does not know why she signed, as this demeanor of DW2 was vital, as she remained silent on such vital question, and later a reply was given which was recorded that the applicant used to take her signature when the monthly payment was made to her for her work as done by the maid. My lord, this is in consonance of the written statement which has been filed by the DW2, my lord. Further appreciation was not made to the extent that the evidence of the defendant number 2, being the wife of the defendant number, used to act on behalf of the defendant number 1. My lord, this is again contrary to what the appellate court has arrived at, my lord, at page 95. At page 95, it says that it is the plaintiff who has to discharge his violent burden to the defendant number 1. Again, here the finding is that defendant number used to act on behalf of the defendant number 1 because DW and DW1 and 2 admitted in regards exhibit so and so, which are clear endorsement that the appellant gave money and the receipt of the same were acknowledged by DW2 so and so as the wife of the. It is natural for a wife to receive payment on behalf of her husband, and these parts of exhibits are not at all appreciated in proper manner. These, the DW2, my lord, defendant 2, her pleadings was that she used to work in the house of the plaintiff, and the plaintiff used to take the signature, how many days she has worked. Now, those things has not been discussed. After discussing, my lord, that issue number 4 of the learned, my lord, trial court has been, my lord, reversed. Further, the learned trial court stated that there are noticeable overwriting and corrections done in the alleged exhibit 2/4 to 2/9. These are the signatures of, my lord, the defendant number 2, which the plaintiff used to take. But careful perusal of the said exhibit does not show any kind of correction or overwriting. Further, such questions as regards to any kind of manipulation is not at all asked from the side of the defendant. And when such question did not made in regard to the presumption as regards to any kind of manipulation is purely misappropriation on the part of the learned trial court. Further, the endorsement that on different occasions DW2 received money which are apparent on the backside of exhibit 2 and which is admitted by DW2 as a signature despite a denial by DW1 is another indicator that DW2 received money, and these facts are not at all appreciated by the learned trial. So on these counts, my lord, it was reversed. Now next page, my lord, 98, para 17, my lord. Para 17, page 98. In deciding issue number 5, the learned trial court took into account that there is no straitjacket formula test the readiness and willingness in discharging the part of the contract, and it all depends upon the overall conduct prior and subsequent to the filing of the suit. The appellant in her suit was successful in stating that an initial payment of 30,000 was made on the day of execution of the agreement for sale, and thereafter part payment were made on different dates, which were admitted by the DW2 while admitting her signature. My lord, only signatures were admitted, my lord. These payments were never admitted because in the written statement, the DW2 has also specifically stated that after paying that advance amount of 30,000, not a single penny was paid. Admitted her signatures, such endeavor shows the readiness and willingness on the part of the appellant to perform her part of the contract. More so, DW1 admitted in his cross-examination that in the year 2014, one village mail was held where he refused to sell the land only at ₹30,000. So now it has come out, my lord. The contention is the total amount was agreed. Out of that, they paid the 30,000 and rest amount was not paid. So therefore, my lord, in the village mail also, the DW1 says that they are not going to sell this land at 30,000. So under these are the circumstances, my lord, under which, my lord, findings of the learned trial court was reversed and the suit has been, my lord, taken. Now, my lord, the substantial question of law, your lordship will find at page 12 and 13. Lordship, what is, my lord, page 12? Yeah. Whether in absence of formal physical partition of a plot of land measuring 2 kata 10 lechas covered by dag number so and so standing in the joint name of Arendra Burman and Girindra Burman, the legal heir of Girindra Burman was competent to enter into an agreement for sale for selling a portion of a joint property with specific boundary. whether in a suit for specific performance agreement for sale of a portion of a joint property, the plaintiff will have the right to claim actual physical possession without partition of the joint property. Whether the learned first appellate court erred in law in directing execution of sale deed in respect of Schedule B1 of the plot of land, which is a part of 2 bigger 10 acres plot of land jointly purchased by Harendra Burman and Girindra Burman, divorce any formal physical partition between Harendra Burman and Girindra Burman. Whether the agreement for sale dated so and so is void ab initio because of lack of authority of the deceased defendant number 1 to enter into an agreement for disposing a specific identifiable portion of an unpartitioned plot of land. Whether the learned first appellate court has misread the evidence on record and had arrived at a perverse finding regarding the readiness and willingness of the plaintiff to perform his part of the agreement dated so and so, divorce any evidence on record relating to fulfillment of the terms of the agreement dated 7/11/2012 by the plaintiff as regards payment of sale consideration amount by the plaintiff to the defendant within a period of 2 years from the date of execution of agreement for sale dated so and so. Whether upon denial of the allegation of the plaintiff by the defendant regarding receipt of the balance consideration amount, the plaintiff had lawfully discharged its burden in establishing beyond reasonable doubt by cogent evidence that the plaintiff had paid the majority of the balance sale consideration amount to the defendant. And third is, my lord, whether the impugn judgment and degree suffers from vices of perversity. Well, my respectful submission is that when this land has not been partitioned, how you can.
Sir,
Yes.
thus you show where the position of law is involved amongst this 7 subsets.
Well, the law, question of law is, my lord, without a lot of land, my lord, without a specific boundary, my lord, you cannot enter into an agreement. Now, without an second, my lord, second this question, whether in a suit for specific performance of an agreement for sale of a portion of a joint property, the plaintiff will have the right to claim actual physical possession without partition. Because it has not been partitioned, madam. Without partition, someone enters into an agreement for sale, and agreement is that I will sell this specific boundary. Now, if you don't have a right to sell that specific plot of land, if you don't have a right, whether you can enter into an agreement for sale that, and even after this agreement is sale, once a suit is decreed, the subsequent, my lord, the purchaser, whether he will have a right, because in the prayer, in the suit, my lord, what is the prayer is to, my lord, if your lordship comes to the suit, which is the prayer of the suit at page number 24, my lord. Page 24. He is seeking further partition. My lord, page 24. Lordship got it, my lord. Prayer A, decree for page 24, 24.
Yes.
Number A, my lord, decree for specific permission, performance, eviction. Number B, decree be passed for partition of the suit land to place the schedule land B1 under separate dakpatta in exclusive title and possession of the plaintiff after sale of the suit land. So after purchasing, he says that I have purchased it, now issue me separate dakpatta. Now the question is, my lord, whether in a suit has been decreed. So whether after a suit is decreed, whether he will have a right to claim actual physical possession without partition. Now, if this prayer be, it means, my lord, placing the cart before the horse. It says that if it is partitioned, he may sell his share, and after his share is sold, the subsequent purchaser is entitled to take out a separate patta in respect of that plot of land. But from the pleadings of the plaintiff, my lord, your lordship has seen that this land was an unpartitioned land. So in an unpartitioned land, whether an agreement for sale with specific boundary can be entered into. This is one aspect. And secondly, my lord, the agreement was to be performed within a period of 2 years. There is no evidence except this acknowledgement of the defendant number 2. There is no evidence on record to show that the plaintiff has performed his part of the contract, her part of the contract as regards payment of the balance consideration amount within the period of 2 years. So in absence of the readiness and willing, my lord, he has not paid, she has not paid means, my lord, she was not ready and willing. So in absence of any readiness and willingness of the plaintiff, whether a suit can be decreed, my lord, for specific performance of contract. My lord. I think these three questions and regarding perversity, my lord, that number 7, my lord, this whether the judgment of the decree of the past by the appellate court suffers from the vice of perversity, because lordship has seen there is a specific pleading that no money has been paid. Now the first appellate court says that no, there is no denial as regards payment of money. So my respectful submission, my lord, is the, my lord, three substantial questions.
To you this number 7 and the other two.
7 and my lord, number 5 and 6, my lord. Because readiness and willingness, because the plaintiff has to come and prove that yes, I have paid this much of amount in presence of so and so, he has to prove by cogent evidence. None of the evidence is there. That
This 5 will be covered by 7.
7, my lord, regarding that, because this is in perversity, my lord, that the finding that there was no my lord, denial that money was not paid. But there was specific denial, my lord, that money was paid. No money was paid. So, my lord, I think 2, 5, 6, and 7. 2, 5, 6, and 7, my lord.
Oh, we will admit the appeal.
Yes, ma'am.
We'll see which out of the 4 suggested substantial questions of law are involved in it, and accordingly we will frame it. The third is the data learning appellate under section 100 of the CPC is directed against the judgment and dignity stated. Nine 7/2024 passed by the learned entitled number 4 of 2023, whereby the judgment and decree dated 36/2023 passed by the learned junior division entitled number 27 of the 2023. Dismissed suit small time struck plaintiff was set aside and cost. There is the memo of excellent the ground mentioned therein and also the six substantial question of law and also there is the impugn judgment and decree with the learned civil judge senior different Baksa level number 4 of 2023 and also the judgment and decree dated 2023 also the civil judge junior different Baksa entitled suit number 27 of 2020. Appeal is admitted on the following substantial question of law. Para issue notice respondents returnable in 4 weeks. Step in declared and search to civilians and also by this is a call for the record from the learned criminal. That's the purpose. No, sorry, learned criminal. It's the purpose.
As regards, my lord, this IA, my lord, at this stage, I would like to not place it because there are some formal defects. There are some formal defects, my lord. This execution case number has not been mentioned. And so, my lord, at this stage, I will not place it. I will file a fresh IA. At this stage, I will not place it.
Draw this.
Not at this stage, I would not like to press it, my lord. I will file a subsequent. I'm deeply obliged.
My lord, in this case, my lord, I sought for some accommodation, my lord.
Ordered.
Can it be on Friday next, my lord?
Lordship, I have some difficulty on Friday. Let it be on Monday, Lordship.
Okay.
Secretary learned advocate for both of them.
Yes.
Next Monday.
4th of August.
4th of August.
Oblige your Lordship.
Please, Lordship. In this particular case, the appellant is affected by the judgment passed by the first appellate court. Well, herein the learned trial court decided all the issues. I will come to that. All the suit on merit. Then the opposite party defendant filed the first appeal, wherein he challenged the order dated 2014 regarding the service of notice upon the pro forma defendants, that was not duly served. And landed first appellate court, what they did, he on that basis of remand the matter, setting aside all the issues without it going to the all issues, whether the 2014 notice part the defendant never challenged, and that order is not affected to this, the present defendants. So I'm coming to, first the plain and the first slightly come to the judgment of the learned trial court, page number 39 and 40. 39 and 40 before coming to all this learned trial court's judgment, that is. This is in page number 33 to 51, Lordship. The trial court 28/11/2022, the judgment, and the operative part is page number 39. 39. Learned trial court, after perusing that, the issue was whether the suit is made for non-joinder or necessary parties, whether the suit is barred by law of limitation, whether the suit is properly valued, whether the plaintiff has right title interest over the Schedule A and B land by way of purchase from the pro forma defendant number 5, whether the plaintiff is entitled to the relief as prayed for. 40. At the time of argument, the defendant filed petition bearing so-and-so, considering 3 issues which were vital in the instant suit. Issues suggested by them as follows: whether the late Sabitri Thapa alone was competent to sell 1 kattha land to the pro forma defendant number 5, whether Sabitri Thapa was the sole absolute owner of Schedule B land, what was the share of Sabitri Thapa in respect of Schedule B at the time sale land to pro forma defendant number 5. So, learned trial court decided all the issues on merit, taking into consideration the evidence and everything. Then, let's see, page number 42. Page number 42 was because I read up 2-3 issues that is important. Then I will come to the first appellate court judgment without discussing anything. Page number 42. Trial court judgment. The defendant raised the plea that the suit is made for non-joinder of so-and-so Barik, who is necessary party in the suit. Josna Khambakar Barik herself withdrew the suit filed against Sabitri Thapa and as such not been able to prove her right title interest over the suit land, as such is not necessary party. Moreover, Exhibit 16 is the paper publication for including the legal heirs of Prem Bahadur Thapa, son of Sabitri Thapa, as well as pro forma defendant 5 Gaur Chandra Roy, from whom the plaintiff purchased the suit land in Dainik Janambhumi newspaper. The issue decided in affirmative in favor of the plaintiff. That was the issue decided, and other issues were correctly decided by the court. Now, let's come to the appellate court's judgment. That is in page number 67 to 82, but operative is 69. Lordship. It starts from 69, then 70. Lordship. Lordship, permit me, I will read this part. It will come up whether the issue which was raised by this court is valid in the or set aside the decree which is been passed on merit after deciding all the part. Page number 70. The title appeal can be preferred in the form of memorandum appeal by learned advocate me Barthakur under order 41 so-and-so CPC against judgment dated 28/2007. The decree dated so-and-so. The case of the plaintiff, one Abhin Narayan Thapa, died interstate. His wife Sabitri Thapa also died, and her son Prem Bahadur Thapa and Prem Thapa wife Shivamaya Thapa also died interstate. Pro forma defendant 1 is the son of pro forma defendant number 2, 3, and 4, and that of Prem Bahadur Thapa. Pro forma defendant 5, Gaur Chandra Roy, purchased 1 kattha land, including Schedule A land from Sabitri Thapa 97. At southern boundary side, land is Schedule B land of the vendor Sabitri Thapa. plaintiff purchased Schedule B land, one measuring 1 kattha from proforma dependent number 5 on 5/3/2005 by registered deed number. And they also got their names muted in 2007. The original of the land was Abhinarayan Thapa. There stood as Assam type structure where Josna Kumar was tenant of Subhama Thapa, had been doing business of tea. The plaintiff attempted to take possession of Schedule A and B land, but defendant number 3 refused to hand over possession. Defendant 1 and defendant 2 are trespassers and they were neighbor tenants of Subhamaya Thapa. Defendant 1 and 2 instituted title suit 11A 2005 against proforma defendant claiming protection of occupancy right and for determining sale deed of 97 as force 1 and permanent injunction. The suit was dismissed on contest. That is their part. That was dismissed. They were there. As the defendant failed to prove tenancy with respect of plaintiff and defendant unauthorizedly occupied the suit land, A land, plaintiff instituted the suit on 12/20/11/2013, praying a decree for confirming the right title interest of the suit land, delivery of first possession of the suit land to the plaintiff, evicting the defendants for cost or any other relief, so and so. Defendant 2 and 3 filed their common written statement on 4/2000. Suit proceeded ex parte against the defendant 1, 2, 3, 4, 5 by order dated 26/11/2014. As per order dated 4/9/2014, suit proceeded ex parte against defendant number 1, but defendant 1 was allowed to file written statement and recording it was filed on 5/5/2015. The plea is that the suit is not maintainable. It has cause of action. Plaintiff have no right to sue. It is time barred by waiver, estoppel, absence. It is also barred by misjoinder of necessary party. The suit according to them is not properly valued, so and so. Abhinarayan Thapa died leaving behind Savitri Thapa, late Prem Babu Thapa, late Ajit Bardu Thapa, late Khagen Bahadur Thapa, late Badri Thapa, and as such 5 legal heirs had equal shares out of 1 kattha comprised of suit dag number so. All the 4 sons alive and at the time relevant time execution registered sale deed. Hence selling entire kattha land by Savitri Thapa by executing registered sale deed to the proponent defendant 5 is illegal. That was raised by the defendant. It is admitted that the proponent defendant is the son of proponent defendant number 2, 3, 4 and daughters of late Prem Bahadur Thapa and Sivamaya Thapa. Defendant have stated that aberrant attempt made by the plaintiff to take possession of the Schedule A, B land, allegation that defendant number 3 refused to hand over possession are completely false, nothing but blatter. It is pleaded that the defendant 2 and 3 originally were tenants of Sivamaya Thapa in respect of suit house in Schedule A plan. Until that filing of written state, they have been occupancy sale. It is averred that under no circumstance, any manner whatsoever, the defendants were tenant under plaintiff not having any right title possession over the suit land during the point of time are not entitled to sue the defendant in their eviction from the suit land. According to the defendants, the plaintiff ought to have instituted a suit within 3 years from the date of their alleged purchase of the suit land mentioned in Schedule A and B. The defendant prayed for dismissal of suit. Learned trial court by order date of 1/4/2000 framed the following issue. Whether the suit bad birth, so these are the issues. During the plaintiff's side, adduced evidence 4 witnesses, including documentary evidence. Defendant also adduced evidence for 3 witnesses. Learned trial court heard argument advanced. At the time of argument, defendant filed petition for consideration of 3 issues. Learned trial court delivered the judgment on so and so, decreed the suit on so and so. Dissatisfied with the appeal order, the appellant preferred the appeal on the following grounds. The grounds as raised in the appeal by the defendant, judgment decree passed by the court as well as not sustainable law. London Municipal Court Sibsagar on wrong appraisal of preposition actual facts persisting appellant grievance highlighted WS of title suit so failed to reflect the point for contestation to its true perspective. Rather dispose the suit framed by her in a very casual manner, so surmises so and so. For that the title suit number so especially highlighted the actual fact in the case of WS. Thereby appellant were also able to prove their case by adducing evidence up to ratio of required by accept their defense case in trial court below and passing said judgment so and so totally failed to take the same into due consideration for such so. For the appellants as defended in title suit number 64/2003, especially stated that the Savitri Thapa was not the sole legal heir.
Mr. Sharma, you have the finding of.
Yes, Lordship. That yes. Then paragraph number page number 77. You now come to page number hearing part. That is 20. From 20, it is important on this. Point to 20. Page number 77, Lordship, permit to only from 20 paragraph, I read out. Mr. Bharat Thakur, learned advocate of
This point for determination.
yes, Lord, I am coming to that part also. So only on the service of the performer defendants, this defendant is challenging that part in appeal. The 2014 order, this is on the paragraph, the page number 77, paragraph 20, kindly let me allow just only. Mr. Bhatt, learned advocate of has submitted a suit for eviction and recovery of khas possession, but the plaintiff being stranger have not prayed for partition. He has further submitted that order dated 11/9/2014 is not proper, and on this ground suit is required to be remanded. He prayed that part only. Then point 4, determination, you not come to page number 79. Paragraph number 27. Page number 79. Title suit number 64 2013, the learned Munsif fixed the 11/9/2014 for service report as revealed from the order dated 11/9/2014. As per order dated 11/9/2014, summons were issued to performer defendant number 13485 on both ways through the process of court as well as register court. Learned Munsif came to conclusion that by issuing summons upon the said defendant in ordinary courts will not serve purpose, because the report reveals that they are not known to persons of the locality. Moreover, if summons are served through usual process, this might linger the proceeding of the suit indefinite period. Learned Munsif number 1 therefore held that interest of expeditious disposal of suit with interest of justice petition praying for issuance of by way of paper publication was allowed. According to provision of Order 5, Rule 15, where defendant is absent from his residence at the time the service of summons is sought to be effected by him on his residence, and there is no likelihood of his being found at the residence within a reasonable time, and the defendant has no agent empowered to accept service of summons on his behalf. Service may be made in the adult member of the family who is so and so. Order dated 11/9/2014 does not disclose the ingredients of Order 5, Rule 15 in respect of summons issued to the performer dependent. There is also no disclosure in the order dated so and so that performer dependent refused to sign acknowledgement, or where service officer using all due diligence did not find them in their residence. It is also stated order dated serving officer affixed the copy of the summons on outer door conspicuous part of the house of the performer defendant. In fact, London Musa did not follow the provision of Order 5, Rule 17 CPC. According to Order 5, Rule 20, if the court is satisfied there is reason to believe that defendant is keeping out of way for the purpose of availing service, or that any other summons cannot be served on ordinary way, the court shall order summons to be served affixing copy thereof summons conspicuous place in the court, and also upon the some conspicuous part of the house in which defendant is known last resided carried on business personally to gain. 11/9/2000 does not speak that summons performer defendant 55 were affixed on conspicuous place so and so. From the facts and circumstances revealed that the breach of provisions of Order 5, Rule 17, London Municipal Critical Order number 11/9/2000 when application substitutes service, it is evident learned trial court failed to apply its mind requirement 5, Order 5, Rule 20, so and so. Here, Lordship. Now come to order dated page number 83, Your Honor. Kindly come to 83. This is regarding the performer defendant. Now I have affixed that, annexed that order also, 11/9/2014. Plaintiffs are duly represented by the counsel. Plaintiff filed petition, so is seeking permission to serve summon upon the performer defendant 1 to 5 by way of paper publication through widely circulated paper Assam Dainik Janambhumi and Amar Assam. The ground stated summons were issued to them but returned unserved as the addresses were not available at the place of their original address. On going through the case record, it transpired that summons were issued to the aforesaid performer defendant number 1 to 5 on both ways through process of court as well as register court. I have gone through the reports of summoning lying in the record is issued to the aforesaid performer defendant number 1 to 5 and come to conclusion by issuing summons upon the said defendants in ordinary course will not serve the purpose, because report revealed that they are not known to the persons of the locality. Moreover, if summons are served through usual process, this might linger the process in the suit of indefinite period of time, which was filed on so and so. Hence, considering the entire aspect of hand, I hold that in the interest of expeditious disposal of the coupled with interest of justice, a petition should be allowed. According petition number so allowed. Plaintiff is directed to take proper steps for issuing summons upon the performer defendant 1 by way of paper publication. And by Exhibit 16, the plaintiff did served through paper publication. Now we have come to page number 84. I have annexed that order also. 26/11/2014. The plaintiff and the defendant 2 and 3 are duly represented by counsel. Proponent number, defendant number 1 to 5 are absent without steps till 12:20 AM. Hence, the suit will proceed ex parte against. This is also proceeding against main defendant 1. Moreover, the written statement filed by defendant 2, 3 has been rejected. In view of the above, the suit shall proceed ex parte against all the defendants. However, the defendant 2, 3 are liberty to cross-examine witness touching by law. So what happened, Your Honor? Regarding the pro forma defendant, which they are taking plea, that has been already through paper publication by Exhibit 16 was done. Here what happened? One thing, but learned trial court committed some mistakes. They accepted the evidence on affidavit of the defendant also. So ultimately, defendant 1, 2, and 3, their written statement was accepted, their evidence was accepted, they also cross-examined. So suit was proceeded on merit against them also. Even though ex parte it was done, but by elapse of time, nobody noticed the conducting advocate. Hence, their written statement was, I have annexed in the appeal. That was also part, and their evidence was, and they took part in the trial also. So, learned trial court, going through the merit, everything was decided the suit. But first appellate court ordered the order dated service dated 2009/11/2014. That is no way prejudice to them. They are illegally occupying my premises. Only because of that, and like the first appellate court, section 99, Lordship, when the decree is decided on merit, in that case, the service of someone, because the pro forma defendant never come up before the court, even after paper publication. 26/11/2014, that is. So here what happened? They are occupying my premises, and first appellate court, taking into consideration only this part, remanded back, setting aside all the issues. And section 99, what it says, when the decree passed on section 69 of the in section 69, 99, sorry. No decree shall be reversed or substantially varied, nor shall any case be remanded in appeal on account of any misjoinder or non the parties, causes of any error, defect, irregularity in any proceeding in the suit, not affecting the merit of the case of the jurisdiction of the court. So they are illegally occupied premises, Your Honor, or learned courts. So in this case particularly, only seeking that direction, directing the first appellate court to decide the merit appeal on merit, not on the order dated 2014. Who is taking this plea? The defendant, who is illegally occupying my premises. He is the pro forma defendant were not served properly by paper publication. So I filed the petition before the court on 11/9. In this manner, the matter will linger. So allow me to through paper publication. And court has allowed the same. On 26/11, court has noted that part also. But learned first appellate court set aside entire merit of the matter as decided by the learned trial courts. So that cannot be. That is illegal. So on that ground, I framed the issue, and that is only the prayer to remand that to decide the matter on merit by the first appellate court. Can you see? Nothing has been touched. And defendant is no way prejudiced by that order. He took part in the proceeding. If he had have been any objection to that 2014 order, he should come for CRP before the court. I am affecting. My mother has sold the land, other has not. Other court here has come for objection. Why he is taking this plea? Earlier he said that I am the tenant. Later he failed. His case, suit was also dismissed, and he filed one suit that was also dismissed. This case, this is a title suit of 2013, Your Honor. Only can you see last page also of that part of the first appellate court. Has appellate court page number 82, in view of discussion, 82, in view of discussion here before, impugned judgment and decree passed by learned trial court are set aside. How they made, when the trial court has decided all the issues on merit, petition document considering the exhibit. And this appellate court committed many illegal activity on the basis service upon the defendant, performer defendant, wherein
By your father's here seven substantial.
yes, yes.
Not
Substantial question as I have suggested here.
which law in fact all
One, Lordship, one part also, one thing, if Lordship permits, section 99, which I forgot to make a suggestion, this is also come up by edit, I wrote it here. Here, first part is that number 2 and 6 are more or less same. You know, 6 kindly come to 6. That I have written. Whether learned to correctly decide the issue number 3 by holding the service of notice upon the pro forma defendants was duly effected through paper publication newspaper as per order dated so and so, and the proved by exhibit 16, and consequently proceeded ex parte against them by order dated so and so, when the present defendants responsible were no way prejudiced or affected by the said order. This is coming section 99 of CPC. How they are affected by this order? So learned first appellate court, what they did, he on this basis set aside the entire judgment of the learned trial court. So my
but which way we cannot accept this sensible question.
yes, section 699, I have formulated that part, Your Honor.
Then you have to
Amendment,
13 in the
no, I have formulated only 7, out of which that's the first part. First is the whether the judgment 30 the appellate court in accordance with the provisions of order 41 rule 31 CPC. First one did I.
So while the memo of appeal is while the substantial question of law part of the memo of appeal.
Yes, sir. That notice was right now. Otherwise, these are covering 3, 6 are covering the entire part. You know, 3 and 6 are covering. 3 and 6 are covering that part. Can you see? Whether learned first appeal are in remanding the suit for any non-compliance of order that so and so CPC in effective substitute service on performer dependent despite due proof of exhibit 16 and no prejudice caused to the contesting defendants. Ultimately, more or less, it will affect section 99 of CPC also, and 6 and 5 is also coming to that part. And 7 I have also included, you know, can see. Defendants being unauthorized possession of the suit land or having contested the suit without disputing the authenticity or validity of exhibit 2 cell deed, which establish appellant's right, title, interest and possession of the suit land, can maintain legally sustainable from partition. From their side, never challenged to anything. My cell deed now never they were challenged. And landed should on the basis of the only of the summon only. So 6 and 3 are covering that part.
Directed against the judgment dated 13 of the 2025 therefore, title number 4 of 2023 to be declared by the new order the appellate court allowed the appeal and thereby set aside the judgment dated 28/11 9 civil judge junior title whereby the original of the was set aside the for best disposal of the so there is a substantial proof of law and the accused then 30, 25 passed by the learned civil judge, passed by the learned first appellate court. In title appeal number 10, 2020 dated 28/11. The ticket dated 9/12/20. Number yes. I think the you can take so passed by the learned. The first one. For past consideration of Code of Civil Procedure and also the order I rule 7/20 of I will do that. There is some of the performance and affected through publication newspaper as per 11/9/2014 and proved by Exhibit 16 and consequently proceeded expertly against them by order dated 26/11/2014 when the present defendants wrote respondents were in no way prejudiced or affected by the state order. Issue notice to the respondents, returnable and employees, by the registered Indian the process will be week from today. This is one for the reports from the learned courts on the of the 4 weeks.
I was just for the stay of the order. I have 2322. That was
Returnable and employees.
page number 12.
So on next returnable that will complete your trade.
Yes, sir. Publish.
Number 1, 183/2025.
May I please your lordship?
Yes.
My lord, a special leave appeal has been filed before the Honorable Supreme Court against the judgment and order of this Honorable Single Bench. And your lordship will find my interlocutory application, that is page 65. Page 65, my lord.
Yes. Yes.
Here, my lord, the direction has been given by the Supreme Court, my lord. We have heard so and so, learned Additional Solicitor General appearing for the Union of India, issue notice. There shall be a stay on operation of the impugn order on the condition of the petitioners as they undertaken by them at page 28 and paragraph 15. Will deposit 10% of the enhanced amount in the registry in the High Court within 4 weeks from today. On such deposit, the amount shall be kept in short-term fixed deposit. There shall be stay on the order of the reference of the court dated 19/10/2024. List the matter on 18th August. Earlier, the 50% deposit direction was given. Subsequently, the Honorable Supreme Court has given 10%. And accordingly, my lord, we have already deposited the amount. Your lordship will find at page 67. Page 67, my lord. This is the covering letter, and page 68 is the photocopy of the check for 41,88,24,706. So we have already complied the order of the Honorable Supreme Court. So that is my submission today, my lord. This may be recorded. But I don't understand why this IA was necessary. The Supreme Court directed 10% deposit. They could have reported it to the apex court and that we have made a deposit. We have nothing to say on that because there's essentially no prayer except for recording the fact that, my lord, that the deposit has been made. The deposit the registry has anyways accepted, my lord. So that is how it stands. But then what has now transpired, my lord, but I find is a area of, my lord, that might require introspection is that while passing this order at page 66, the apex court directly it does not state the order relating to deposit. At first part, it says the order relating to deposit. In the second part, it states directly the reference court order without discussing anything about the fate of the LA appeal that your lordship had heard. In fact, that hearing was concluded, lordship knows in Itanagar bench. So what would be the fate of the same? As of now, there's no clarity on this order because normally apex court would not stay the reference court order directly, bypassing the statutory appeal forum. We are planning to, my lord, file a clarificatory application in this regard from the apex court so that there is absolutely clarity as to what will be the fate of the LA appeal now, which is before this court, my lord. Will the apex court directly hear the issues or will it say that the High Court has to hear this? That this is ancillary, of course. This is ancillary, of course.
Big file along with the OTC will take on board.
Yes. Yes. It's only on. It's a matter relating to taking on record only. Because what happened, the reference court order to be stayed with the deposit of 10%, that is why it has been filed with a deposit of 41 crores. So that has to be recorded and this stay order may be passed. That is my fear. If it, Supreme Court has already passed the order, but earlier this was the order when on deposit of 10% minor, the impugn order will be taken. So this 10% is subject to notice again. We are yet to appear before the apex court. It is an interim measure that the Supreme Court has said that since you had yourself said it is 10%.
But we find that it's the original record of payment to the company. Respondent said how to process it. We follow it from the office of the deputy person.
Yes.
Original record.
Yes. In fact, your lordship would recollect, I had filed a separate IA in this regard also as to the payments. There was a IA, separate IA also.
I have accepted the order.
My lord.
But while it was the court for right, then I find that part.
My lord. Therefore, I filed the IA, my lord, for calling it. My lord. Because
the main order, the main case, LAF will pass that order.
My lord.
Calling for those original records for that.
My lord. Because during the hearing, I also went through the record and I could see that this would be necessary. Therefore, I filed a separate IA that the deputy commissioner has to produce this now.
Applicant one to 104. The total learned for the petitioner applicant submits that the applicant has referred one SLP to the open court. SLP part SLP part 1 and part 6 stroke 2025. Upon which the report by order dated 5 at state the order of the reference court dated 1994 subject to both of 10% and amount the registry of this court in 4 weeks from today. Mr. Dodo further submits that person who said order of the Honorable Supreme Court, the that reported that person of to the registry of this court being 41 crore.
41 crore 80 lakh
41
88
crore 8 lakh
24,706.
706 for this. And further, although it's some extent, the same kept the same take on record. It may be taken record LA appeal number part sub although it for the applicant and also hearing Mr. Pathak of this scope of this introductory application by or taking record the order of the report and the file in the in the LA you pick up or for the appellant and Mr. Pathak but it appears that in order to decide the issues raised for this court at the time of hearing of the appeal, perusal of the original record of payment of compensation, the respondents hearing by the Deputy Commissioner Basar, Leparada District, Basar, found to be necessary and accordingly, it's provided that it's also the original record of payment of compensation to the respondents number 1 to 104 from the office of the Deputy Commissioner, Leparada District, Basar, in a period of weeks from today. Like that.
Problem.
My lord, with leave of the court, I'd like to make a mention. My lord, it is in respect of that LA appeal number 1 of 2025, which my lord is of the opinion to be lifted tomorrow. Lord, owing to the land compensation matter from Vishwanath Charan. My lord is well aware that the matter is also listed today in the execution court. My lord, the opposite counsels over there, they are making submissions to the court that they will be filing application for issuance of NBWA against our official. That is the pressing issue which has compelled me to come before my lord.
No, I have directed the registry to place the matter to.
My lord, but today they are in the process of filing such applications.
Let them file it.
My
Why you are afraid that
I'm not apprehending, my lord. We are officials, government officials, my lord. Nothing else. And
so that your in your demand that could be
Lordship, he cannot be present, Lordship. He is in the Biswanath Sariyali, Lordship. He will come by 1 August, Lordship.
Pardon?
1 August, Lordship. He will return on 1 August, Lordship. 1st August.
my lord, when the
Lordship,
matter is on the verge of a decision by this honorable court, my lord, they are actively participating in this matter here and arguing it vehemently. They're coercing us over there, my lord, by threatening to file such applications for issuance of NBWA to the court. We are government officials, my lord.
Lordship, in Biswanath Sariyali Court, Lordship, they have not filed any petition, Lordship, yet.
No, they have made an oral submission in
Lordship,
court seeking leave of the court to file the application. That's why I'm saying they are on the verge of filing it. They have made this submission in the open courtroom there, my lord.
file. Take care.
Lordship, at least they should file a petition and let the court know about the status of High Court, Lordship, but they have not filed any petition. Just Haziras are filed from their side.
We are standing there. We have already filed one application on the 20th of June, my lord. And today also we are there filing this application. Only change we are bringing about is that my lord has fixed it for tomorrow again. That is why we are amending that application, my lord, which we are there filing.
Tomorrow we'll hear. Then if another order is being passed by the learned trial court,
My lord.
what is the court?
My lord. Hello.
If they ask your senior present pro BC,
Lordship, I will ask.
I think I have.
Obliged, my lord.
May it please the lordship.
Yeah.
My lord, this matter,
what is your stand?
My lord, if it is reverted back, I have no.
well, the core issue was whether there is a head-on collision between a wagoner and a truck, or whether the wagoner dashed the truck from behind. Eyewitness to the accident, where all people died, says that it was a head-on collision at the end of the truck. The charge sheet filed by the police is against the truck. Now, the insurer of the truck makes a stand, even identifying the husband to be a wrong one, and says, no, the truck suffered some dents from the behind. So therefore, it is the wagoner is at fault. It dashed from behind. Somehow, rightly or wrongly, the learned tribunal accepted that, ignoring other things, and gave a formula that you get this much amount from your insurer. In all fairness, the things, person has died, would be blamed that there was his fault. So we are saying that let it go back. Whoever is to pay will pay. Whether it will be a portion 50-50 or entire thing by truck, that's a different account. That's what he is also saying. Let it go back. Without allowing all the parties the right to cross-examine all the witness. That's all. No further documents. All parties get right to cross-examine all witnesses.
No, during trial, you have not been allowed to proceed.
No, we have cross-examining. What we are on is that since the core issue is whether it is a head-on collision or the wagoner dashed the truck from behind. To that extent, limited examination be allowed to all, not only to me. Let them also do the same. Let the others also do the same. Only on that point.
No. Is it your case that you have not been allowed to cross-examine?
Everyone has been allowed to, but learned tribunal.
Then
Look,
why should
learned
we
tribunal.
again allow you to?
I leave it to your lordship. Because
like,
no, we are not proving curing a lacuna. We have been awarded an amount. I'm not even praying for modification of the award, raising the amount. I'm not on that. What we were saying that a man has died, and that's the client's version, of course, that we were not at fault. The observation is that we had dashed the truck. Let it be done. Insurance would pay. Whoever is to pay would pay. So our insurer would not pay. If the learned tribunal says 50-50, okay. If then again says no, they has to pay, then okay. But the head-on collision part, we are trying to bring it on record. That's all. Because I have got the relief.
You come to the ground, so you have mentioned this application.
But Lordship finds at page 3. Number B. May I read that, page 3.
Yes.
For that, the evidence of PW2, that is Administrative Officer of the Respondent number 5 Insurance Company, having made it crystal clear that the police had submitted charge sheet exhibit 3 against the offending truck, the learned tribunal failed to appreciate the matter in its entirety by sifting the evidence, and as such, the learned tribunal erred in law in settling the liability of the award on respondent number 5 and not on respondent number 3. As such, the amount awarded so and so liable to be modified. For that, the learned tribunal, having placed reliance on the report of the motor vehicle inspector of the truck, outweighing the conclusion reached by the police authorities, committed manifest error of law as also facts. These are the two core grounds which I have said. The eyewitness and police are saying one thing, and the insurer of the truck, even wrongly identifying my husband, is saying quite another. These were not properly appreciated.
And the observation was that no, we had hit them, the truck from behind. The award was given in our favor. It's not that award was not given in our favor. The award is in our favor. But somehow or the other, for this observation, this appeal was filed. Nothing more. They could have happily taken the money and left. Yeah, well, it came through me, so I just pointed it out. A reconsideration of the matter.
We'll examine your part.
Response number 2.
Ordered in the
Yes, Lordship. Not yet, Lordship. Otherwise, whatever I get. That's okay. But only for the blame gaming part, you would want to rerun or reconsideration attached.
will be get done something the belief for
Madam, Lordship. Obliged.
Number 20 order.
APG Lordship.
give up for the petitioner.
Yes, my lord.
The respondents are absent. They
Yes.
whether this matter was admitted.
It is a 2016 matter, my lord. Probably it has been admitted, my lord. Because I am also engaged later on in the later part, recently, my lord.
You have also filed on IA.
IA has been disposed of.
When?
There is an order to that effect, my lord. IA was for continuation of delay. It was disposed of earlier. But if I may submit, my lord, regarding the matter.
You were not sure whether this matter was admitted or
Lord.
Are you prepared to argue the matter?
Yes. If my lord sees the earlier orders, my lord, passed by Honorable Mr. Justice D. Borua, my lord, the earlier engaged counsel were informed through the registry of this court that this matter is pending. And in one or two occasions they have appeared for a short time also. And on the last occasion they did not appear.
Lord, Lord, no, Lord. Oh, Lord, oh, oh, yeah. Oh, yeah.
Obliged.
Made the lordship. In this case, service complete and LCR also received, lordship. The case is ready for hearing. Your lordship fix a date, lordship, convenient to your lordship.
Lord, Lord.
For R4. Lordship, I'm representing respondent number 4 here.
Go, go, thank you.
Jay Singh, Lordship.
Yes. Oh,
150.
it's updated the bar that
As per office note dated 16/7.
complete that HCR has also that 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 admission yet. Yet. That go yet.
1, 2.
1 to 3 are also necessary, party lordship. As per office note 16/7, service complete. But their name has not been shown. No one is representing them, lordship. So if your lordship record that service for 1 to 3 complete, in spite of that, no one appeared.
Order dated
16 dated, office note 16/7, it may be normally written 2023. But it should be 2025.
oh, okay.
16/7, Lord. This regular first appeal was admitted on 9/8/2023. So, Lordship, this office note ought to be 2024 or 25. Lord.
But it was effective. It has been mentioned that service completed, but how?
Lordship, nothing was mentioned. We have checked, and as per 22/8/2023, notice was sent, Lordship, long back. So your lordship may direct registers because 1, 2, 3 is necessary, lord, they are necessary, lord.
So the office SIC indicates that service completed, yet the take of silent to how the service was affected. Accordingly, provided that the detail of stop indicating how office was the service of office of respondent number 1 to 3 were affected, taking the method of
Lordship, some other respondents are also there. Pro forma respondent 5 to 8, lordship, 5, 6, 7, 8.
and 5, 8.
After a week, lordship, next. Oblige.
After number.
In this case, I am representing respondent number 2 and 3, lordship. Lordship, kindly see order dated 14/2/2025. There was a direction given to the engaged counsel to verify the address of the respondent number 1 and thereafter to take step.
None appears to the appellant of how the murder. You have all the respondent.
Lordship 2, 3, 1 not yet complete, lordship. And last occasion also they did not appear, lordship.
It also appears record that all side of the appellant with the matter on think of payment of sub non-repeated orders of
As per office note dated 29/5/2024, my lord. Service has been taken on 6, respondent 6, 9 and 10. On respondent 6, the AD card has been received with signature. And on 9 and 10, it is still awaited, my lord, service report.
I'm representing only 1 to 5, lord.
I'm representing 11 to 14. 11 to 14 are state respondents, my lord. HK Borua, my lord.
report as number 1 to
5, lordship.
1, 5, 7, 14.
14. Can I just point out one fact, my lord?
Yeah.
6 to 10 are.
Respondent number 3 to 10, they are all sisters. And 3 to 5 are appearing. 6, the AD card has been received with signature. So, and
But it is not legible.
it is not legible. She is the sister of 3, 4, and 5.
I'll take instruction, lordship, whether I can appear for them, whether they will send wakalatnama or not, lord. I have received wakalatnama for 1 to 5 only.
Third, for the reference that those statements taken that yet notice there's number 6 later the AD card of the notice that's it plays and later AD card not respect 9, 10 return till date. It's further pointed out that number 3 to 10
3 to 10.
all are brothers and sisters.
All are
Yeah.
Brothers. That is so they started for the just for 1 5 substance. company instruct APA respect the or 610. Is the matter on
Note, interim stay may be extended, my lord. There is an interim stay.
Obliged.
Yeah, Mr. Lordship. Lordship, in this matter, my lord, service report has already been completed and respondent number 1 and 2 has appeared. But regarding 3, none has appeared yet. But you know, 3 is the mother and 1 and 2 are the brothers. We're referring for 1 and 2. 1, not 3.
so you were appearing as number
1 and 2, your lordship.
1 and 2.
Yes.
How many respondents are there?
3.
3 respondents, ma'am.
But
3 is the mother of respondent number 1 and 2, man.
you cannot appear on behalf of the
Beg your pardon, lordship.
you have no instruction to appear on behalf of respondent.
No, your lordship. I have received the wakalat number on behalf of respondent number 1 and 2. So I have
Any
appeared.
of the instruction.
Okay, I have to obtain instruction.
But sir, not learned. Appellant and also part Bora for 2. Obviously, 5 instead. Service completed. But the silence how third number was affected. Of one office ticket to how was served. The products and how to update instruction as to whether it can appear on behalf of the number who happens to be the father of the or 180.
1.
After a week, after
Much obliged.
29.
Right.
May it please your lordship. As per office note dated 24/7/2025, your lordship, we have filed our affidavit in regard to paper publication upon the sole respondent. So your lordship service is complete. This matter.
further as the total also so for success. So paper publication, the subject and that also quite effective. Including the paper. Dated on which date it was published?
Your lordship, 9/7/2025.
9/7/2025. That's affidavit and data paper that appeared that it will start of the response. But yes. on behalf of the with the method for admission hearing after 1 week.
Okay. Much of.
Here in this case, we are directed to take steps upon respondent number 1, 2, and 3 by paper of application, Lordship. The publication was done, but we have filed an affidavit today only.
Lord Mr. S. Sona, Lord I for the applicant. Said, garbage of the were affected by substance that by paper of and yes, filed affidavit including the concerned paper, but the including the affidavit filed by the
Obliged. Yes. Okay, this case has a checkered history, my lord. Lordship kindly see page 65. The first order was passed by your lordship 4th of January 2024. The operative part, page 72, my lord. That though, however, there is a conflicting views of the different high court about maintainability of the revision petition against an interlocutory of this court, considering the ratio laid down by the Supreme Court in respect of doctrine of binding precedent in the case of so and so. So on the basis of this, my lordship has held that the criminal revision is not maintainable, my lord. Thereafter, lordship, the matter went to the Supreme Court, page 74, my lord. Supreme Court, my lordship, having heard learned counsel for the petitioner, we are not inclined to interfere in the matter. The special leave petition is hence dismissed. However, liberty is reserved to the petitioner here to file a writ petition under Article 227. Thereafter, my lordship, the next page, my lordship, another the case writ petition was filed, page 75, my lordship. The revision bench of this honorable court held, my lordship, that the writ petition under Article 227 is not maintainable, and the 81 is the be that as it may be, at this stage number 6 liberty to withdraw the petition and to approach this court in terms of liberty granted. Thereafter, this present petition has been filed, my lordship, and after notice, my lordship, it is coming before your lordships. The case of the petitioner, my lordship, the interim award, my lordship, which has been granted by the learned family court, page 22, my lord. And the operative part, my lordship, is page 23.
So this letter is the order for
For admission.
you are for
I am for the sole respondent. This 10th was in my lordship as interim ready asked in 2023, July, my lord, without considering the, my lord, the financial affidavit, the status of the respondent, my lord, I will show from his financial affidavit, my lord. He is a man of money, my lordship. He is sufficient properties, my lordship. He has 2 cars, my lordship. He is maintaining car, my lordship. And what he is showing, my lordship, he has shown a 29 years son as a dependent. He is a chartered accountant earning 79,000. But here in financial affidavit, he has shown 29 years son as a dependent, my lord.
anyway, we will fix the matter for hearing. So it is the order column.
And my lordship, short date because he is still suffering, my lordship.
Yes, yes.
Because otherwise, 10%. lordship, there is nothing in this case, lordship. Lordship, may kindly see page 73 or lordship's order. This honorable court directed while disposing of the case directed the learned family court to expeditiously dispose of the case pending before the learned family court. Page 73, paragraph 16.
This order went to Supreme Court thereafter another, for merits, my lordship, it has been come before your
However,
lordship.
during pendency, it was found that the petitioner suppressed material facts and concealed information in her affidavit in
It is all
affidavit,
as,
lordship.
my lord, we have done
Therefore-
this,
therefore we
the
filed a
family
petition
court,
under
we have opposed this. And
Therefore, we filed a petition under 91 CRPC, lordship. And after filing 91 petition, the learned court below directed the petitioner to produce the records. After production of the record, we again filed a petition under section 340 CRPC regarding perjury, lordship. After filing this petition, the petitioner side also filed such type of petition. And lordship, those petitions are pending for hearing before the learned family court. The petitioner again filed a DB case before the learned CJM Kamru, and that was originally transferred from Coimbatore, Tamil Nadu, lordship. And in that case, on the last date, on 26/6, the learned court below has directed to pay rupees 10,000 for house rent, lordship.
which
So
is
at
not
this
changed.
stage, there is nothing already in the form of interim means they are getting sufficient, lordship. I am regularly paying the interim amount 10,000 regularly. I am paying, and the order of the learned CJM is under silence before the learned session court, lordship. And that is passed only on the 26/6. As of now, they have no grievance because what they sought already 20,000 interim is provided, lordship.
I am here for enhancement of this amount.
Till now, lordship, they have filed 8 petitions before the learned different forum, lordship. They first filed a complaint before All Women Police Station, Tamil Nadu, lordship. Thereafter, they filed DB case in Coimbatore. Thereafter, they filed SLP before the Honorable Supreme Court for transfer of the DB case to Guwahati High Court.
Transfer petition not
Again, they filed 125 petition before Family Court Guwahati. They filed CRP. The Honorable Court has passed the order, lordship, and dismissed the CRP. Then they moved to Supreme Court. Again, they came to High Court. High Court filing writ petition, that is dismissed. Now they have again filed this CRP IO, and in the meantime, they have also filed a petition before the Chief Judicial Magistrate Kamrup Metro under DB Act, lordship. And in that case, on 26/6, they are provided residence order, lordship. Apart from the order of maintenance of rupees 10,000 per month passed by the learned family court. So
That
as
is
of
for
now, she is getting 20,000, lordship.
residential accommodation, and the amount awarded by the DB court towards rent has not been paid, my lordship, in spite of the order.
Sir, LL learned is this matter on 13th of August for adjournment.
Obliged.
My lord, can it be a little later, lordship?
My lord, 2023 orders, my lordship. 3 round of
He is
litigation.
getting.
I have to come from Delhi,
2
my
orders
lordship.
from different court. I have some difficulty, lordship. I have some difficulty. On the 3rd week or 4th week of August, lordship. 4th. April. Obliged, lordship.
It may be 23rd if possible. Saturday. Then Monday. 26th August. Obliged.
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 May it please, your lordship. This case, lordship, respondents are appearing.
I am appearing on behalf of respondent number 1 to 16. I filed a wakalatnama. My name is not reflected here. It was filed on the Friday 1 to 16.
How many respondents are
There are 26 respondents, lordship.
26
As per office note 24/7/25, service complete upon some of the respondents, lordship, and 18 to 21 and 5 not found the addressee in their proper address, lordship. But 5 my learned friend is representing. 18 to 21, lordship, they are also degree holders. So my learned friend can take instruction whether he can appear or not.
I'll take instruction for 18 to 21.
Lordship already granted.
Sir,
A short date may be given, lordship.
for what to?
16 I have filed wakalatnama 1 to 16.
1 to 16.
Yes, your lordship.
1 to 16. The Sotori submits that
As per office note, lordship, 18 to 21 and 5 not found in the addresses. So 5 already he is appearing, lordship.
as per office dated 24/7/5, notice the notice issued to the respondent not be served as they could not found the address. And then respondent number 17, 18 are all degree holders, and as such, it sums that current concept preparing for respondent 116 may also obtain correct whether PA or rest of the respondent. Mr. Mukherjee sums that he will take accordingly by the
Lordship, as regards
the week.
lordship,
After a week, and lordship, respondent number 22 to 26, lordship, they are judgment debtors. They will not be represented by him, lordship. We are the third parties, and Mr.
22
Modun
to 26.
22 to 26, lordship. Their service complete, lordship.
When?
As per office note 24/7/25, lordship. First column, lordship, service complete in respect to 2, 3, 7, 8, 9, 10, 11, 12, 13 are 22 to 26. First part of that office note. Service report of notice issued by usual court process.
View of the office dated 24 service of or something, but they are represented after week.
Yes, lordship. In this matter, lordship, there was no interim given at the time of issuing notice. But there was
Your name is not there in the cause title. Oh, no, sorry, in the cause title.
Yes, lordship. S. Roy and B. Hazarika, my junior's name appeared.
This is the reflect the name of this Sotori and
Deeply offensive.
So this I is for condonation of delay lordship, 252 days.
50?
252 days.
34.
May it please, lordship. Lordship, this I is for condoning the delay of 20 days in filing this appeal.
This one of
Later.
35.
11 days delay, lordship, in filing appeal. 11 days delay.
11.
Lordship.
Okay. Okay.
Okay.
36.
I put a condonation of delay. I put a condonation of delay. 13 days.
13 days. Okay. That's all.
19 days lordship delay.
38.
Yeah, please. This IA is for condonation of delay of 24 days.
How many days?
24 days.
24. Okay, let notice go.
Most of this.
96 days.
40.
Please, your Lord. Also, here is a 155 days delay for preparing this regular second appeal. Okay. Obliged.
The lordships, containing the delay of 5 days.
5 days.
Yes,
Notice.
Delay of 33 days.
Okay. Let
Like that.
Then,
non-appeal for the appellant not based on after week. One.
Notice note dated 21/5/2025. Notices have been issued to the respondent number 5.1 to 5.3 by registered court. But registry is saying that no step for usual process was taken, Lordship. In fact, Lordship, we have taken step by usual process also.
Part for the appellant. Dated 6/2025 indicates that service notice is for 5.1 return with a report and accuracy not known return to the center and notice to the for 5.2 return a report accuracy not be located RTS and notice notice it to the for 5.3 such person RTS. So to the further subset, so to the subset, she has also taken state of appropriate assessment by usual process. When you have taken the step.
Lordship, by the same order, Lordship, 19/8/2024.
Person the order of this court dated 19/12/2024.
19/8/2024.
8. Better you take step again.
Lordship.
To obtain inspection respect of the one.
Yes, Lordship, no such address could not be located, so I have to take step, Lordship, and proper address.
It is provided that the complaint address give up a
So I'm appearing on behalf of Mr. P.K. Dekhalot.
He is representing 1 to 4, Lordship.
1 to 4 and 6. Lord.
1 to 4. Sir, your name?
No.
Your name?
Joint to me, J. Medi.
J?
Medi. J. Medi.
Yeah.
On behalf of Mr. P.K. Dekhalot.
Sir, P.K. Dekhalot.
P.K. Dekhalot.
Press receive of the for 5.1 to 5.3 by registered ADN within a week from today. Let the matter appropriate.
Lord, obliged.
Obliged.
May I please, Lordship? Lordship, IA is for withdrawal of the civil revision petition, Lordship.
Third, sir,
B. Malakar, Lordship.
B. Malakar, learned counsel for the applicant.
Lordship.
This certificate application heard by the applicant for according for withdraw. CRP Applicant IO number 67 of 24, filed by the learned counsel for the applicant submits that he has the instruction to withdraw the share number, there be IO number. According, this there be IO stands dispose of on withdrawal. The liberty would be required.
No, Lordship. Already decided the matter, Lordship, in outside and court, Lordship. But there is a stay is there, Lordship, so they may be vacated.
Stay granted, stay if any granted earlier stands vacated.
Items for stay 43.
In terms of the
May I please, Your Honor?
yes,
Item 43. Steps have been taken today. Your Honor.
today,
Yes. I'm a widow, my lord, and having no source of income, and also driven away
But
from my
your
maternal.
name, please.
UN Secretary.
You went secretary.
Yes.
Learned counsel for the applicant. So secretary submits that he has taken step upon the respondents to pay on. According to it, is provided that the matter after 4 weeks awaiting service.
My stay may be extended till the returnable date.
Stay for entry order passed earlier.
44.
Highly appreciate.
Lordship, this is transfer petition. This is the transfer petition, my lord. And opposite party, they have filed an wakalatnama on 22nd, my lord.
When?
Their name has reflected in the cause list, my lord.
When?
My lord, 27 probably.
Of this month.
My. There is a tag mark in 27 office note, my lord. Their name has also reflected in the cause list.
Name reflected in the cause list.
My lord.
Or Mr. P. Soikia, learned counsel for the petitioner not appears for the respondent. Although the name of the advocate namely
Case in. Item number 44.
the name of one Mr. Case in a learned counsel has been reflected. The counsel is the matter after a week. In the event of subsequent non-representation, the respondent appropriate for the
My lord, there is an interim of that. That may be.
Much.
This transfer petition is being filed for transfer of the title filed by the husband before the district judge Bongaigaon to Golpara.
My lord, I am appearing for the respondent. My lord. I am appearing for the husband respondent. So, my lord, I may be allowed 1 week time to file objection because
where the case is pending.
Basically, the case is pending before the district judge Bongaigaon.
Bongaigaon.
I am staying with my parents, my lord, without any income. My minor son is also staying with me at Golpara.
Golpara.
My
You at Golpara.
My lord, second ground is, my lord, that he has filed a guardianship mistake under the guardianship at Golpara, my lord. In that case, I am also a party.
my lord, the one thing, my lord, I am submitting that I will take instruction whether if it is placed in the Abhayapuri, then both party from your house, Abhayapuri, my lord, next week your lordship may fix the matter. Abhayapuri district is then. But now,
Or Mr. P. Hazurika, learned for the appellate and so or learned counsel for the respondent. Sir, not submits that it may be allowed to allowed 1 week time to file objection and also to obtain instruction as to whether the case can be transferred to the court of learned additional district judge at Obeyapuri.
Obeyapuri, ma'am.
Obeyapuri.
There is no cause of action at Abhayapuri, my lord. He has filed a case at
No, within this district.
Gwalpara, and that driver should file at Bongaigaon.
That is at
The
Bongaigaon.
guardianship act is at Gwalpara, he has filed, my lord.
Obeyapuri is the subdivision of
Bongaigaon.
Bongaigaon.
Bongaigaon district.
I am staying in at Dudnoi with my parents, my lord. And he has filed a case for guardianship at Gwalpara, my lord. I am praying for transferring to the court of Gwalpara. Same court, my lord. If he can come to the court of Gwalpara for the
Next week, my lord, I will take it, sir. Next.
the letter. Price for one time period is allowed after a week.
After the interim order that will be complete.
My lord, I am very sorry, my lord. Item 51, I am appearing for the respondent number, all respondents. So, my lord, let the matter next week, date may be given, my lord.
Already fixed next week.
Date may be given. And my presence may be recorded. Date may be given, because that matter, I am very sorry. On my instance, matter has been listed, madam, on my instance. But I am very sorry, I am engaged in another court, madam. And any date may be given, madam.